just starting the YouTube stream now. I see people are entering.
Great, just tell me when you're ready.
You should be all set.
Okay. Good afternoon, everyone. And to everyone out there in TV land, welcome. I'm Harold French, Senator from District 7. Today, we will be holding a meeting of the Senate Commerce Committee. Before we get started, I'll read through a checklist to ensure that the meeting we're about to hold is in compliance with the Right to Know law. As chair of the Commerce Committee, I find that due to the state of emergency declared by the governor as a result of COVID-19 pandemic, and in accordance with the governor's emergency order number 12 pursuant to Executive Order 2020-4 and its extensions, this public body is authorized to meet electronically. Please note that there is no physical location to observe and to listen live to this meeting, which was authorized pursuant to the governor's emergency order. In accordance with the emergency order, I am confirming that 1, we are providing public access to the meeting by telephone with additional access possible by video and other electronic means. We are utilizing Zoom for this electronic meeting. All members of the committee and selected legislative staff have the ability to communicate contemporaneously in this meeting through this platform. And the public has access to watch and or listen to this meeting in live time on Zoom or YouTube, and via phone by following the directions and links provided on the General Court website. We have provided public notice of the necessary information for accessing the meeting in the Senate calendar. We are providing a mechanism for the public to alert the public body during the meeting there are problems with access. If anyone has a problem, please email remotesenate@leg.state.nh.us or call 603-271-6931. In the event the public is unable to access the meeting will be adjourned and rescheduled. Please note that all votes taken during the meeting shall be done by a roll call vote. Finally, let's start the meeting by taking a roll call of attendance. When each member states their presence, please state where they are and if anyone else is in the room with you during this meeting, which is required under the Right to Know law. I'll start the roll call. Senator Bradley.
I am in Wolfboro. I'm in my office and I'm alone.
Senator Susie.
I am in Manchester. I am at home and I am alone.
Senator Kavanaugh.
Hello, Kevin Kavanaugh at my home in Manchester, and I am currently alone.
Senator Gannon.
Senator Bill Gannon, I'm in Sandown. My Zooming Timberlane students may walk through, and my wife is also working out of the house today.
And once again, I'm Harold French, Senator District 7, broadcasting from my living room in Canterbury, New Hampshire. No one's in the house. The doors are locked. No one can get in, nor can I get out. We'll start the meeting. We've got 3 bills today we're going to be going over. And we'll be starting with Senate Bill. Find my papers. Was it 39? Aaron?
63.
Pardon me?
63.
63 with Senator Guider. Senator Guider
Collins,
on board?
Be able to unmute yourself.
Senator Guida is here. For the record, Senator Bob Guida, Senate District 2, speaking in favor as the prime sponsor of Senate Bill 63. And I introduce at this hearing Amendment 024S. As you might examine, there's considerable, might imagine there have been considerable discussions and changes and so forth that ultimately produced this amendment. And so I'd like to speak to it. The origin of this was from the Business Industry Association. seeking to develop some means of protection for businesses from frivolous lawsuits regarding, generated out of the COVID-19 crisis. The U.S. Congress had stated that they would address the issue and never did. And so as a result, I brought this bill forward this year. The bill does is establishes, if you will, a process, a method, and standards for filing legislation against a business for purportedly causing COVID or COVID-related harm to an individual. It goes through some definitions. Those are pretty much self-explanatory. The negligence on Roman 2, line 12 of the Amendment 240S is worth discussing. It means an act or omission that, when viewed objectively from the standpoint of the actor, that's the business, creates risk to patrons or customers by operating in violation of the guidance promulgated by the Governor's Economic Reopening Task Force, including CDC and any other reference guidance therein, as soon as practical, but not less than 6 business days from the adoption of the guidance by the task force. There's a lot there. Rather than expect our businesses, large and small, to, if you will, fish the internet or whatever resources for multiple guidances, as a member of the Reopening Task Force, we have incorporated into our guidance both CDC and other federal agency and safety agency recommendations for the various industry groups. So this allows, if you will, one-stop shopping for any business to discern the appropriate measures in effect in this state at the time, at this time for compliance and for operating the business. So we establish here essentially a standard that says you need to be engaged in business responsibly. As soon as practical, but not less than 6 business days from the adoption of the guidance by the task force. The task force was initially meeting every day, but only putting guidance out probably 2 or 3 times a month through HHS and the governor. And so 6 business days is a week and a day. So on the first day after a week's respite from new guidance, a business would be expected to have checked in and discerned what guidance is appropriate, and to have been able to comply with whatever that guidance may be. We say, but not less than, as soon as practical, because in some cases there are things like recommendations for improving HVAC systems or changing heating systems, and those things don't take 6 days. But as practical, I think a business would be able to show that they've made a legitimate attempt, but that a contractor wasn't available or the HVAC system wasn't available. And again, just to provide some guardrails to enable, a level of compliance that is measurable. Entity originally started out as business, and we offered then we decided to include political subdivision, government agency, public, private, or parochial academic institution, religious organizations, or houses of worship. If they're complying, they should not be subject as well to litigation. Personal injury definition was developed with some eye towards constitutional concerns. And I'm not an attorney, but I think that the attorneys that I ran this by deals in this and said this is a necessary component other than the original definition that was in the original bill. We have a standard here that we call clear and convincing evidence. And there was much debate between the Association of Justice and myself about whether that standard should be clear and convincing evidence or preponderance of the evidence. And while I understand their arguments and concerns, we're dealing with a virus here. We're not dealing with a broken glass or a hot water tank or a hot water coffee machine. We're dealing with something that is really not tangible, that travels sometimes in ways we're not sure of. And so rather than have just, a better than even chance, we wanted to make sure that we had a standard that made it clear that the person got the virus at that establishment as much as we could. And again, remembering that the original purpose of this legislation is to protect businesses from frivolous lawsuits. Liability exceptions are pretty self-explanatory. And of course, we set a statute of limitation of 3 years as opposed to the original bill's 1 year. And with that, I'm happy to take any questions.
Any questions from the committee members? Seeing none, thank you very much, Senator.
Thank you, Senator, and members of the committee.
Cameron, could you invite Senator Morse to speak?
So I was informed Senator Morse no longer intends to speak.
Okay, then would you cross Senator Morse off the list?
Will do.
Take the next one, please.
Okay, next is David Creer. David, you should be able to unmute yourself.
Yes, thank you. My name is David Creer. I am Director of Public Policy at the Business and Industry Association of New Hampshire. Thank you for listening to me. Thank you to Senator Gaida for putting this bill in. This is one of the biggest issues that our members are facing right now. It's top of their list in terms of priorities. This bill would provide protections against COVID-related lawsuits from people claiming that they contracted COVID-19 at a business. This is especially important given that the businesses are trying to remain open during a pandemic. And as the pandemic continues, we would like to see our businesses remain open so that we can continue having, as strong of an economy as we can, given all the conditions. These cases would be difficult to litigate, meaning that there's going to be a long legal process with some extended discovery because, the nature of contracting COVID-19, and we learn more about it every day, it's just a really long process, which could cost a business $30,000, $40,000, $50,000 to defend against. And, this would be especially hard on some of our smaller businesses. The funds that are used to, and the resources that are used to defend oneself against a lawsuit, that could be better spent on keeping your employees, saving up, trying to recover from lost revenues as a result of the pandemic, and so on. I do want to point out that this bill, and as I understand it, the amended version, would only apply to a business that is following state and federal guidelines. So if you are not following the guidelines that are promulgated by the state or federal government, you would not be subject to the safe harbor provisions of this bill. Meaning, if there is someone who is harmed because they contracted COVID-19 at a business that decided, well, we're just not going to put up barriers, we're going to let everyone sit in the same room, no masks, that person can still sue and receive the money in their damages. And also I want to mention, because this has come up as well, some have said that this bill would really just protect insurance companies because companies would be protected by their insurance. Many insurance companies would not cover COVID-19 related lawsuits because they have exceptions for communicable diseases, which means that all of the legal fees would, or, depending damages would be on the business. They would not get anything else from that. I've also heard that there is no need to have this because no cases have been filed in New Hampshire, but nearly 200 have been filed across the country, and they will come here eventually, especially if they're found successful in other states. So we have a real opportunity here to prevent this from becoming a problem before it starts, rather than reacting to a problem. With that, happy to take any questions. I know probably have a lot to do today, so I'll end there.
Thank you, Mr. Creer. And I've got a question. Of those lawsuits that were filed elsewhere, how many of them do you know were filed by patrons of the businesses versus employees?
That I don't know. I'd have to go back and look and see if I can dissect that information for you.
So BIA, are they more concerned with lawsuits from patrons or employees?
I think we would be more concerned from patrons and other third parties that are entering the business. My understanding is that under current law, an employee would have to go through workers' compensation in order to get damages for COVID-19 related injury. And I don't believe this law would change that. So they would still continue to go through workers' compensation.
Thank you. So they would be looking at this legislation to protect the businesses from lawsuits from patrons that should be aware, I mean, at this point, that COVID-19 exists and there are risks, correct?
Yeah, and you know, it's not just patrons, but yes, patrons would be a large one. Also, any third-party contractors, they're not employees of the business, but say they go in to install new lighting systems or something during the pandemic, they wouldn't be covered under the workman's comp of that business because they don't work for that business, if that makes sense.
Great, thank you. Any other questions from the committee members? Senator Susie?
Thank you, Senator French. Mr. Creer, could you find out, you said there were 200 lawsuits filed statewide. Could you find out what states those are in? Is it possible
Sure.
to provide the committee with the breakdown? The reason I'm asking is because different states have different damages that can be awarded, and New Hampshire is not a particularly generous state. So I'm curious to find out where these lawsuits are occurring.
Sure. I think a big portion of them are from California and New York, but there's also been some, I think, as close as Connecticut. And the rest, I will have to look into that, and I'll email the committee with that information
Thank you
later.
so much. Appreciate it.
Thank you. Anyone else? Thank you for your testimony today.
Thank you very much.
Cameron?
The next person on my list is Marissa Chase. However, Senator Gaida has his hand raised.
Go ahead.
Senator Gaida, you should be able to unmute.
Yeah, thank you. I just, again, I think Mr. Creer iterated what I was going to express. That employees are covered under workman's compensation. So that's all. Thank you very much.
Great, thank you.
Okay, as I said, next person on the list is Marissa Chase. Marissa, you should be able to unmute yourself.
Hi, can you hear me?
Yes, we can. Go ahead.
Hi, Senators. Thank you very much for taking the time to hear this important bill. My name is Marissa Chase. I represent the New Hampshire Association for Justice, and respectfully, I would like to defer my time to some attorneys that are more knowledgeable on the subject than I am, and perhaps come back if there's anything else that needs to be covered.
Great, thank you very much.
Okay, the next person on my list is Paul Chant. Paul, you should be able to unmute yourself.
Yes, can you hear me?
Yes, we can. Thank you. Go ahead.
Good afternoon, Senators, and thank you all very much for your service. I'm speaking both as a member of the board of NHAJ, but also as a partner and lawyer in what I think is the biggest law firm north of the Lakes region here in New Hampshire. My firm represents hundreds of small businesses that range in really every area, from CAD firms to manufacturing firms to hospitality firms to restaurants to banks to you name it. And candidly, we have not heard the clamor in this firm for this type of relief. What I'm hearing from our business clients is that they want to do the best job they can to be as safe as they can so that they can keep their businesses open and operating. They're more worried about making sure they do things right now than they are any future risk. I mean, we had six restaurants in this valley, big restaurants closed in the same week, a week or two ago. And these restaurant owners are making sure they're doing the best thing they can so their employees are safe and their customers are safe. This liability risk, which has yet to show itself in New Hampshire, simply is not a significant issue on their screen. In this firm, I am not a corporate lawyer, but I am approached all the time by the other corporate lawyers in this firm when they have issues with insurance claims or liability risks, because I know that area of law. That's where I work. And I can tell you that these issues are not out there, as they want to follow the rules make sure they're following the rules. And more important than anything, they want their employees and their customers safe. New Hampshire's law is such already that if the businesses just do that, they have no COVID risk. I'm going to suggest to you that the pitch here is a little bit off from where you're getting it, and that it's really not appropriate. The pitch is that New Hampshire does not offer adequate representation, and that this bill is necessary for COVID claims for New Hampshire businesses that follow state and federal guidelines. Well, guess what? If you follow state and federal guidelines as they've been set by different entities, you followed the law. You have not violated any standard of reasonable care, and you've created no risk for yourself. So the temptation may be to say that there's a problem here and we need to go take care of it. But New Hampshire's law already covers this problem and covers it well. If you do your job and you follow and use reasonable care, you will not be found liable in this state. And reasonable care, the standard of care for these cases is exactly what the representative that introduced the hearing today was saying. You know, it's what the state and the federal folks came out with. And if you follow those, you're fine. We don't need to change longstanding New Hampshire law to address something that if our businesses are doing it in accordance with those guidelines, they're already protected. Lastly, I just want to say that echoing Senator Soucy's comment, this is a conservative state. And it's a conservative state with juries. It's a conservative state with valuation of claims. We don't have punitive damages. We don't have runaway jury verdicts. And you're not going to get them in any COVID type case. If you have any questions, I'm happy to entertain them. But I think this is one of those things where if there's a interest in changing law for cases that haven't been brought here yet to provide protection for businesses that properly run their business in accordance with standards, which is already our existing law. And I really think it is that simple if you really look at the law the way it is. Thank you.
Great, thank you. Any questions from the committee? Seeing none, thank you very much for your testimony. Cameron?
Okay, the next person on my list is Neil Nicholson. Neil, you should be able to unmute yourself.
Terrific. Good afternoon. Can you hear me okay?
We can, go ahead.
Fantastic. Thank you, Senators. My name is Neil Nicholson. I'm a past president of the New Hampshire Association for Justice, and I am a small business owner myself. I run a small practice here in Concord, Nicholson Law Firm. I run statewide and handle litigation work and also do work for nonprofits and church institutions around the state. I want to just kind of take a step back really and go foundationally here to what we're talking about when we talk about an immunity bill, which is exactly what this is. It's providing immunity for businesses under certain circumstances consistent with what's been drawn up on this bill. And when you think about immunity, you have to think first about, oaths. And what I mean by that is there's three oaths that I want to talk about quickly. One is when I was a police officer, I took an oath that I would uphold and defend the Constitution every day that I took a shift and went out onto the street to protect the citizens of this state. It was an important oath. It was one that I hold near and dear to my heart. The second oath was the one that I took as a lawyer, almost the same exact oath where I indicated and I swore that I would defend and uphold this great Constitution that we have in our state. And the third oath is the one that you all took as legislators to do the exact same thing as senators, to uphold and defend the Constitution. In fact, this year I had the privilege, frankly, to be on the call, the executive counselors meeting where Governor Sununu swore in all the legislators. It was a very, it's technologically difficult to do so this particular year, but where the oath was given over the phone. And so I listened to the oath and I understood that it's the same exact oath, or if not very close to what I have also sworn to in the past of upholding and defending the Constitution. And when you pass an immunity bill, whether you think it's right or wrong, justified or not justified, good or bad, understand that when you pass an immunity bill, you are removing constitutional rights of a New Hampshire citizen. And so you have to think through it very, very carefully and understand exactly what it is that you're doing. And this is what I mean by that. And this is the importance that our founders for this state and our Constitution, let me read from Part 1, Article 20, a very important component that talks about jury trial in civil causes. And under our state Constitution, Part 1, Article 20 says, in all controversies concerning property, in all suits between two or more persons, except those in which another practice is and has been customary, and except those in which the value in controversy does not exceed $1,500 and no title of the real estate is involved, the parties have a right to a trial by jury. This method of procedure shall be held sacred. Now, this word sacred is particularly important when you think about the context. The Constitution here, written June 2nd, 1784. And I got to tell you that in 1784, the use of the word sacred, given the custom of that time, was even much more valued than how we use that word sacred here today. And sacred means consecrated, sanctified, hallowed. I mean, it carries with it some weight. And no other place in our state Constitution is the word sacred used. The only time in our state Constitution this word sacred is used is when it's talking about a jury trial in civil causes. So when you pass an immunity bill, which you can, the legislatures can strip away people's constitutional rights. And as a constitutional Republican myself, I understand that very well. But when you're doing that, understand that you are removing a constitutional right that is currently enjoyed by the citizens of our state. And this is an important substantive right. And I do not think that the law will be ultimately found to be held constitutional. I don't think that it'll pass constitutional muster under Carson versus Maurer. I think that it's arbitrarily increasing the burden of proof on COVID claims, and that's unreasonable. And I think that any conceivable public benefit conferred by this COVID immunity bill it's outweighed by the restrictions it imposes on private rights and a right to a jury trial. So thank you for your indulgence listening to me. I really appreciate it and trust that you will just consider the importance of the constitutional implications with passing such a bill. Thank you for your patience with me.
Thank you. Any questions from the committee? Seeing none, thank you very much for your testimony.
So Senator French, there are two representatives, Representative Stapleton and Representative Edwards, who both have their hand raised, as well as Lexi Rojas, who I believe works at the Department of Labor. Do you want me to continue with the list, or do you want me to bring one of them in?
No, bring them in, please.
Okay. Representative Stapleton, you should be able to unmute yourself.
Thank you very much. I wasn't intending to testify, but listening in, I wanted to make known that I have also filed a House bill. I don't have a number for it yet, but it was under LSR 210129.1. Similar bill, except that my bill is a little broader in coverage because it focuses not just on businesses, even with the expanded definition that has been announced for SB 63, but persons. And in my bill, it has an extensive coverage under persons, including profitable business, nonprofits, individuals, persons, churches, social and civic organizations, and so forth. And my bill focuses on the rebuttable presumption of liability waiver. And if everyone assailed under a lawsuit has taken every good faith and reasonable measure to follow the obligations and the protocols and the rules, suggestions of the state and federal government, CDC, and so forth. But the rebuttable presumption doesn't eliminate the possibility of a lawsuit. It's not a blanket immunity. It is rebuttable. So if there is good faith by a business person, or entity, and yet there's a lawsuit that comes forward, there still has to be a trial for the proofs. The complainant's going to have to make a case as to how he derived COVID and damages from entering a business or person.
Representative, just to interrupt you for a second. Please keep your remarks on this bill. And when your bill reaches us, if it does, we will talk about your bill at that time.
Okay, thank you very much. And I forgot to mention that I'm from Claremont. I'm the Claremont Ward 3, Sullivan County District 5 representative. Sorry, I didn't announce that earlier. And thank you for hearing my reference to my bill. Thank you.
Thank you, sir. Cameron, could you call Representative Edwards, please?
Representative, you should be able to unmute yourself.
Thank you so much. I'm Representative Jess Edwards, representing Rockingham District 4, Auburn, Chester, and Sandown. I hadn't intended to comment today, but I think a few things have come up that I felt I needed to address, and that is that we've just gone through, and we're still in the midst of an unprecedented government reaction to a virus. And government has been shutting down businesses and restricting businesses in the name of public safety. And in many of the cases, I think constitutional issues, such as whether or not churches could meet and meet with only 10 people, meet without singing. There have been some infringements on constitutional principles already. And so to come out, I should say I'm not a lawyer, by the way. I am a hobbyist of the Constitution. But I think coming out of this pandemic, given that we've beaten down our businesses and been willing to explore the boundaries of undue takings of their property from them by restricting their use of their property, I don't think that it's a constitutional insult to allow them the business certainty of allowing them to emerge from this pandemic as the emergency orders are lifted, so that they can focus on what they should be doing as their core businesses. They should be focusing on taking care of their customers, on their employees, on their business model. And the last thing we need to do is to unleash lawsuits to trip them up and harm them yet again from this pandemic. So I think if we can craft this bill so that it doesn't protect the truly negligent, that it is in the public good to get our businesses back up. As a former member of Ways and Means, I can tell you we need the tax money, and that tax money is good for our taxpayers, and it's good for the people who rely on our services. So there's a lot of moving parts here, and I would hope that you can come down helping our businesses emerge from this government mandated restriction on their business by giving them a government aura of protection as they get back on their feet. That's it. Thank you.
Thank you, Representative. Any questions from the committee? Seeing none, thank you very much.
Thank you.
Cameron?
Okay, the last hand we have raised is Lexi Rojas, who, as I said, I believe works for the Department of Labor. Lexi, you should be able to unmute yourself.
Hello, good afternoon. I am an attorney with New Hampshire Department of Labor. My name is Lexi Rojas, and we weren't intending on speaking today, but there seemed to have been some questions about workers' compensation insurance law. And so I just wanted to state very briefly that under RSA 281A8, all employees are presumed to have accepted that they will be that the Department of Labor is the forum on which any work-related injuries are to be adjudicated. And then specific to COVID-19 and how that's impacted the department, the hearings thus far, employers are required to report any and all injuries that are work-related. We have had roughly since March 1st, 2020, when COVID became became a more apparent impact, we had roughly 35,000 first reports of injuries filed, and about 3,200 of those listed COVID-19 as an injury. Now, a first report of injury is not an acknowledgement or an acceptance of a claim. It is just someone telling the employer of an injury and the employer filing it as a notice of potential injury. So it's not a definitive statement that COVID was obtained during as a result of work. Of all of our COVID-related first reports of injuries, only 6 have risen to the level of a disputed hearing in which an insurance carrier denied that it was work-related and the employee disputed it and brought it to a hearing level. If anyone has any interest in additional questions for me with respect to workers' compensation and how it applies in these types of matters, I am available.
Thank you. One question. So if an employee gets COVID-19, automatically they get workers' comp or not?
So they would have to it would have to raise to a level of a claim.
Yeah.
And if it's disputed by the employer, they would get some of the benefits until the actual hearing is done. And at that time, it would be decided on whether or not the transmittal of COVID-19 or infection of COVID-19 was work-related. The burden of proof is preponderance of the evidence. So the question is, out of everything that this employee has had contacted with, what about their work made them more susceptible or more likely than not than they contracted it at work? It is, although it doesn't sound like a very high burden, it isn't an easy thing to obtain or prove at a hearing.
It's not. Okay, so I guess my question is, if an employee came down with COVID-19 and died from it, would they be in line for death benefits if any were offered through their workplace?
So they would be, I'm not sure about specific to the employee contract and what type of benefits they have through work, but the spouse can get benefits through workers' comp. Not for, if the spouse were to be injured or had been contracted COVID-19, that's a separate matter. But if the spouse was widowed because of, the employee unfortunately died of COVID-19, they can go through our process and they are entitled to some benefits like lost earning potential, lost wages potential because their spouse is now deceased and no longer able to support at the level they were when they were living.
Thank you. Any other questions from the committee? Senator Bradley?
Yeah, thank you very much, and thank you, Ms. Rojas. So if I understood you correctly, there have only been 6 claims that went to a dispute hearing, right?
That's correct. Only 6 of all the claims that have been filed, only 6 rose to a disputed level.
And what is the universe of the claims filed?
I'm not sure I understand. I'm sorry.
So 6 out of some number of claims filed went to a dispute hearing. How many claims have been filed?
So I don't know how many of the first report of injuries filed turned into actual claims, but so there could, so I don't know how many of those 3,200 turned into claims, but 6 were disputed. So for the 3,200, either they didn't rise to the level of either they were denied and no one contested it, or they were accepted. And then then out of those 3,200 that were either denied or accepted, 6 were disputed.
All right, so there were 3,200 reported, what do we call it, incidences of
Work-related incidences.
Okay. Great, thank you very much.
Thank you.
Anyone else? Seeing none, thank you very much for your testimony today.
Thank you.
Cameron,
Okay,
anyone
we
else
are-
waiting?
Nope, we are back on the list. Senator Bradley, did you?
Are we at the end of the speakers?
We've got
No.
a few more.
Oh, I'm sorry. Ignore me.
Okay, the next person on the list is Tony Scullambrini. Tony, you should be able to unmute yourself.
Thanks, Cameron. Can you guys hear me?
We can, go right ahead.
My name is Tony Scullambrini. I am a lawyer. I'm practice in Nashua. I own my own firm along with my partner, Leslie Gill, and I'm speaking in opposition to the bill. There are a couple of things that I wanted to point out to the committee that may impact the committee's decision, but certainly go to something that the committee has brought up or other speakers have brought up. So one of the things that I wanted to talk about specifically is the way in which the bill's definition of liability or exception to the immunity could give rise to a place where small businesses are actually worse off than they were before. So if you look at the bill says that you have immunity from regular negligent acts, but then it says that there are exceptions, and the exceptions to the immunity are for willful acts. Let me make sure I get the language exactly. So they are gross misconduct, willful acts, the 3 exceptions. Those 3 exceptions mean that we're talking about only having liability when the employer is doing something intentional. When you match that language up to typical exclusions in an insurance policy, that means that if they are sued, the small business owner, and they make it through because there's no protection from this immunity bill, then the small business owner is out of luck. The insurance companies won't cover their defense. And the reason why is how the insurance company typically defines coverage. So the policy says we cover you for X, Y, and Z, but not for A, B, and C. Most policies have a definition that only covers accidents or negligence. So for example, in a typical policy, it will say an occurrence means an accident, including continuous or repeated exposure to substantially the same general harmful conditions. The other language that's often used is bodily injury or property damage is excluded when it is expected. This exclusion does not apply to bodily injury resulting from the reasonable use of force in defense of person or property. So those 2 phrases that often show up as ways of limiting insurance coverage mean that anybody who's sued under this COVID statute, who is not covered by immunity because their actions fall into one of the 3 forms of conduct that waives immunity, will be out on their own. And so really all of this does is it limits the insurance company's coverage requirements. It doesn't provide mom and pop with more protection. In fact, in many ways, based on the way that insurance policies are typically written, it provides them with less coverage. They're going to have to file a motion to force their insurance company to defend them by saying, no, it wasn't expected or intended injury, it was an accident. And then they're going to go from there. So I think that we need to be careful of the law of unintended consequences. The second point that I wanted to make is this. The idea that the bill is necessary, or even that the clear and convincing evidence burden of proof is necessary, is simply not backed up by the facts. So the person that spoke from the BIA said, there's lawsuits from all over the country. We're really concerned about this. It's, we're going to try to cut them off at the pass. So the numbers that I have indicate that there are a substantial number of cases in California. And when I say substantial, I mean 96 total cases. And California is by far the highest state. The next highest state on the list is Texas with 63. So if you combine all of New England, that is Massachusetts, Connecticut, Maine, New Hampshire, Vermont, and Rhode Island, you get roughly 14,855,000 people. In that 14.8 million people, there have been 4 COVID-related suits. So we're talking about less than 1 in a million, way less than 1 in a million. In fact, just for reference, I looked up while I was waiting. What else happens at roughly this frequency? You have the same chance of being killed by a poisonous plant or animal as a business has in getting sued for a COVID-related lawsuit. 1 in 3.713 million people in New England have filed a COVID-related lawsuit. There are none in New Hampshire. So the idea that this is a burning need, as Paul Chant pointed out, is simply not true. Not only is it not true because, as Paul Chant pointed out, businesses are probably doing other things, but it's also not a burning need in terms of the cold, hard facts. I took my population numbers from the US Census Bureau. I took my COVID cases from numbers from Johns Hopkins, and then the COVID cases in total was provided by, I believe, a source for NHAJ. I'm sorry, this is the COVID-19 complaint tracker from Hutton, Andrews, and Kurth. My final point that I want to make is that when we're talking about following the guidelines, that's a really important thing, because if they follow the guidelines, these businesses already have protection. The guidelines being referenced here are the same guidelines that would be referenced when people are trying to figure out what the reasonable standard of care would be for a business in this situation. And what we don't want to do is we don't want to create a bill where the only people that can be sued are business owners that essentially lick the face of every customer that walks in the building. That's not what we need to be doing. And by setting the burden of proof and the standard of proof so high, that's effectively what the legislature would do if it passed this bill. Lexi Rojas, who is a friend of mine, used to work in the prosecutor's office when I was a defense lawyer. She talked from workers' comp. She talked about the fact that there were only 6 contested hearings. Workers' comp is a streamlined process, and so it offers something of a preview of what New Hampshire's civil bar will be doing. And if there's only been 6 cases in the entire year, I don't think that there's a deluge of cases waiting to strike the state of New Hampshire. I think this is a made-up concern by the BIA, and I think that their claim that they're trying to head this off at the pass only serves insurance companies. And finally, if you look at the course of cases for really serious COVID-19, think about the pitcher for the Boston Red Sox. Eduardo Rodriguez has some of the best medical care in the entire world. He was infected at the beginning of the pandemic, and he wasn't cleared to walk until late September, early October of 2020. This is something that tells us that the most serious cases will take longer and be more difficult to litigate, which should be a safeguard for businesses that follow all of the regulations, policies, and procedures. If it takes more than 7 or 8 months for someone with the best medical care to figure out what's going on, the idea that there's all of these lawyers out there waiting to run into court and slap people with lawsuits just doesn't make sense, both in terms of the numbers and in terms of the medicine and the science. So for these reasons, I oppose this bill.
Thank you very much. A couple questions.
Sure.
Have there been lawsuits filed in New Hampshire in the past over contracting a sickness or a disease from like a restaurant?
Yes. So
there have been.
In fact, this is something that I'd spoken to with a colleague before about. These cases remind me of like food poisoning cases. And food poisoning cases, while they do happen in New Hampshire, they're exceptionally uncommon. And if you think about how food poisoning happens, it's easy to see why. People don't eat once a day. And even in COVID times where we're in a pandemic, we still have to go get gas, go to the grocery store. And so isolating where you get the food poisoning is going to be as difficult, or, at least shows us how difficult it could be in isolating where you contract COVID. And so I think that that's a really great point, Senator French. And I think the analogy is a strong one. The one thing that I would point out is that because of COVID's prevalence in society, it's going to be even more difficult for lawyers to isolate the critical link to show causation and exposure at any one place in COVID as compared to something like a food poisoning case.
Thank you. Any other questions from the committee? Senator Gannon.
Yep. Thank you for taking my question. So one thing I got out of what you said, though, was maybe this is a lagging indicator that the lawsuits, they're small now, but as the cases go, you said it's going to take time. People aren't even going to know they have a case or be prepared to do it till the future. So the volume of cases that you're saying small now will grow quite substantially in the future.
I don't think that's true. And the reason why I don't think that's true is because while it might take some time to identify these cases, the workers' comp system and its streamlined process kind of gives us a preview of what's coming down the road. So if there was this lurking tidal wave of cases, we would first see it in workers' comp. And the reason why is because there's both a streamlined process and because if you think about it, the places that would be targeted by these lawsuits, they're all businesses that are employing people, and those people are obligated to go to workers' comp. So they are sort of the canaries in the coal mine. And as Lexi said, there was only 6 of them last year that went to a contested hearing. So I do think that there is a chance there is a lag, but I think that we have enough data here to make a guess that lag is not concealing, thousands of cases about to deluge New Hampshire small businesses.
Thank you.
So one last question. What would be the damages for contracting COVID-19? What could possibly be the damages if you didn't die from it? Lost work maybe? What would be awarded in the state?
So Senator French, that is also a good point. When you talk about a civil suit, you really talk about 2 buckets. There's the delineated costs, your medical bills, lost wages, things like that. And then there's a bucket for pain and suffering. And those are really the 2 sources of a recovery that somebody that's in a civil suit can expect. New Hampshire, as was pointed out, doesn't have punitive damages. There's very, very little way other than the enhanced compensatory damages to get anything other than your medical bills paid and your pain and suffering compensated. And so, the cases where people get COVID-19 and it's really, really bad, where it permanently impairs them or it kills them, those are relatively few and far between. The numbers are going down, as we can see with the data. The rate of death based on the per person contracted the disease, in other words, the number of people that die versus the number of people that get it, is going down. And I think that those 2 buckets, most of the time when people get COVID, they're not going to have enough in the way of medical bills and pain and suffering to warrant a lawsuit. Almost all of these suits would certainly be brought by lawyers working on a contingency fee. And that means that they're footing the bill. They're taking the financial risk in bringing this suit. And if it doesn't pay out, they lose money. And so for a lot of reasons, namely the fact that COVID's most extreme cases are getting less common, and the fact that most of these cases are going to be taken by lawyers working on a contingency fee, I just don't see a wave of these cases that is large enough to make lawyers who are footing the bill want to file suit. I mean, they're very few and far between. And the ones that are few and far between, they're not going to be protected by this bill. I mean, those are the ones that people are going to go to court for anyway.
Yeah. Okay, great. Thank you very much.
Thank you, Senator French.
Cameron?
Okay, the next person on my list is Christopher Seifert. Christopher, you should be able to unmute yourself.
All right. Well, that's pretty good. Christopher Seifert, Seifert Law Offices, Franklin, New Hampshire. 2 minutes of your time, please. So I'm just an old lawyer practicing up here almost 4 decades. I know some of you personally. You're all straight shooters, and so am I. So I got to ask, why is this bill before you today? Most of you have other things that you could be doing. I got other things I could be doing. But we're hearing, I guess, some doomsday projections by the BIA. But where's the New Hampshire proof of need? So here's how I see it from almost 40 years of practicing law. I tell my business clients, just act reasonably, follow all governmental guidance. If you act reasonably, that's all our New Hampshire law requires of us, that we act reasonably. I had the privilege in 2012 of trying the Tom Morgan case to the New Hampshire Supreme Court. And here's what the Supreme Court emphasized in New Hampshire of the very moral fabric of a civilized society is this: responsibility for personal malfeasance runs through all relations of individuals, each of us to the other. That's the New Hampshire way. This bill would remove that moral fabric and incentivize bad behavior and remove this reasonable standard that we all owe each to the other. I don't think this bill is needed, and I ask you not to pass it. I'll entertain any questions. Harold, you got one. I see you.
I do, but you just drove it out of my head. Any questions from the committee? Senator Gannon's got one.
Yeah, I'm also a simple country lawyer like you, sir. How you doing today?
I'm doing good, Bill.
So reasonableness, it's sometimes I think I know what it is and sometimes I don't. So I do a lot of work with schools. I see a lot of schools using these purple lights at night and they sterilize the classrooms. They move them all around. Other schools, I don't see that. And so I'm worried about what the term reasonableness is going to mean down the road when they have hearings to decide, well, you didn't put the purple light in to kill the bacteria. And I'm saying I couldn't afford it. I'm worried that if we don't raise it to a higher standard, people are going to get caught and get in trouble when they think they're acting reasonably.
But if
one school might put these purple lights in to kill the bacteria, another might not. So if we raise the standard a little higher, just so the businesses feel they're not going to get sued.
So if that's a question and the governmental guidance says use the purple light, and a school or a business doesn't use the purple light, then they haven't acted reasonably.
Well, I don't think they've been, if I can follow up.
Yes.
Oh, sure. Go ahead.
So if it's just not the purple light, I see some schools that I go in are replacing every water fountain, even though they're not being told to because they think that's a potential transfer site and they're putting in the hands-free stuff. So one school's doing it, one isn't. I don't think the standards are clear enough that people know exactly what reasonable is anymore.
Well, I'm not sure that I can answer that question well, in that if the government has come down with standards and we're following them, we're being reasonable. If we want to go over and above those standards, we're free to do so.
Right.
Okay, thank you.
Any other questions? Thank you, Chris, for your testimony.
Thank you.
Okay,
Cameron?
the last person I have signed up to speak is Bill Woodbury. Bill, you should be able to unmute yourself.
Good afternoon. Thank you for allowing me to speak today.
Thank you.
So my name is Bill Woodbury, and I'm an attorney practicing in Laconia, New Hampshire. I serve as the legislative chair for New Hampshire Association for Justice, and I'm here speaking in opposition to the bill today. I first wanted to say thank you to Senator Gaida for listening to our thoughts and our concerns on this bill. We appreciate that. And I want to echo the comments of my colleagues, Paul Chant, Neil Nicholson, Tony Scombrini, and Chris Seufert. So I won't belabor those points. They've spoken to the constitutionality of this bill. They've spoken to the fact that it's not necessary. And I would speak, I guess, a little bit more to the practical reality of it, which Tony touched upon. And that's that, it's been suggested that, this bill is going to prevent, the frivolous lawsuits. And every time, the corporate world, tries to push an immunity against liability through, that's what we always hear. It's kind of a tired talking point, prevent the frivolous lawsuits. But the reality is every time, we challenge them on it, we ask, well, what frivolous lawsuits? We don't see them in New Hampshire, and they can't produce them because they don't occur. They don't occur because attorneys in this state, we are expected to perform and write our pleadings and bring our cases, to a high ethical standard, and not bring frivolous lawsuits. If by the time I sign a pleading that's going to be filed in the Superior Court, I need to be real certain that I feel I can bring that case and I can prove what I need to prove. And in this case, if anyone's thinking that the lawyers are just laying in wait for the big wave of COVID-19 suits, that's just not the case. I've spoken to, at this point, I don't know how many of my colleagues about, these bills and the things we would have to prove. The stark reality is that it would be exceedingly difficult to prove a case of this nature. And I believe it was Senator Guida that said, well, look, I'm paraphrasing, but I believe he said something to the effect of, this isn't a garden variety tort case. This is a virus, and we have to raise the standard a bit to clear and convincing. And I would respectfully answer that in saying that's just not the case, because if it's our burden to show that an entity, a business, has acted unreasonably, that's a high bar. And if a business has implemented all of the things that the state agencies and the federal agencies have said constitute a reasonable attempt to prevent the transmission of disease, then they have acted reasonably, and we don't need to raise that standard. And anytime we start to do that, anytime we try to codify that increased burden, then we go down a bad road, and so again, I don't want to belabor what my colleagues have already said. I incorporated here, and just want to emphasize that these are not cases that anyone is going to be just laying in wait to bring, because the expense of epidemiologists and medical providers who would even venture an opinion that someone contracted COVID-19 in a particular environment, it's going to be exceedingly difficult. So I'd be happy to speak to any questions the committee has.
Thank you, Mr. Woodbury. Any questions from the committee members? Seeing none, thank you very much for your testimony today.
Thank you, Senator French.
Okay, that's everyone I had signed up to speak. Currently, there are no hands raised. Marissa Chase has raised her hand.
She wants another chance?
I do,
Go ahead.
Senator. I'm sorry.
Go ahead.
I really want to keep you all. My name is Marissa Chase. Again, I represent the New Hampshire Association for Justice. Senator Gannon, if I may, and I know you went to law school and I did not, but just to answer your question about the guidance at the time and what the schools, some schools are taking precautions, others aren't. The bill is very explicit, and so is common law, that no one could be held liable for a standard that came about after an alleged act. They would be subject to the recommendations available at the time. And I just wanted to clarify that point.
Thank you.
Thank you.
Thank you all very much. And I will say, we've appreciated taking a lot of Senator Guida's time as well, a lot of your time, and we would be more than happy to perhaps form a working group or participate in any conversations about the specific language of the bill. And I do want to stress that I believe the attorneys testifying today were speaking to the bill as introduced, not the amended version.
Thank you.
Senator Bradley, is your hand raised in reference to Marissa or? Okay.
Good. If there's no other speakers, I'm going to close this hearing on Senate Bill 60. Senator Bradley?
Is there anybody from the insurance department? signed in on this bill, available on this bill?
Let me take a look here.
Christian with his hand up, he's from the insurance department.
Okay. Christian, you should be able to unmute yourself there.
Yes, I'm here.
Great. Thank you very much for taking my question. There was testimony that we received about this bill protecting insurance companies because they're the ones that have riders on their policies that exclude businesses from this kind of protection for a pandemic or communicable diseases. Could you further illuminate on that?
My area of expertise is actuarial science. So I'm a property and casualty actuary. So I do not spend the bulk of my time looking at the policy language. I will say that most general liability policies, which is what I think would cover these incidents or the types of instances that are being considered with this legislation, most general liability policies do have carve-outs, do have exceptions for communicable diseases. In fact, I'm seeing a lot more such endorsements being filed as rules, just to clarify the language and make it very, very clear that they do not intend to cover communicable diseases. And now what I do not know is what types of businesses, are predominantly covered by these types of policies. For example, in these communicable diseases exclusions, there is usually a carve out for restaurants dealing with, a foodborne illness or food poisoning, something like that, where they would still cover that situation. And so I would, if you want more details on that, I can certainly talk to folks at the department and the lawyers and those that are more familiar with the coverage language. But my understanding is that many companies are writing the policies with the intention in a general setting, like in a retail setting or office space setting, that they would not cover communicable diseases.
Okay, thank you.
Senator Kavanaugh.
Thank you. Thank you for taking my question too. So is there any carve-outs for intentional acts then? I know you brought up carve-outs for intentional acts in liability cases and policies, I mean.
Yeah, we're going beyond the scope of my comfort area, and I would certainly follow up with folks back at the office of the lawyers. But generally speaking, if they will not cover illegal acts. So, when it comes to intentional acts, if there's an intentionality involved, a lot depends on whether the business is being covered or the individual, the employee is being covered. So, if it's a large company and one of the employees goes and starts, beating on a customer, for example, yes, they will cover to the extent that the business might be liable, but not the individual. I'm gonna follow up, and we'll get back to you, Senator Kavanaugh, on that to be sure. But that is my general understanding.
Okay, thank you. I appreciate that.
Thank you. Anyone else? Seeing none, thank you very much. Cameron?
There are no hands raised at this time.
Senators? Is it all right if I close this hearing? Thank you. So I'm going to close the hearing on Senate Bill 63. We're going to be taking up Senate Bill 65 next. There's a lot of speakers. Before I open the hearing, I'm going to suggest everyone take a 3-minute break and stand up, stretch, and come back in 3 minutes, and we'll be starting. I should have said 5 minutes. Everyone feel better?
Good to stretch the legs.
Yeah, definitely. Good. If everyone's ready, I'll open up Senate Bill 65 and turn the gavel over to Senator Gannon while I introduce it. And
Thank
again,
you. Thank you, Senator French. Okay, at this time, we're going to introduce Senate Bill 65, and the Honorable Harold French will present the bill. Go ahead, Senator French.
thank you very much, Senator. For the record, once and for the fourth time today, I am Harold French, Senator for District 7, and I'll be introducing Senate Bill 65. This bill, it's the repeal of the prohibitions on the sale of over-the-counter rape test kits. That's the bill. Last year, we put in a prohibition that I didn't necessarily agree we should be doing, so I brought it back for another look at it. Looking at the list of people that want to talk about it, maybe I shouldn't have, but no, it's this bill. Last year, we put in a bill that prohibited the packaging of lawful items that you can pick up at any store, any pharmacy. And we stated that if you put them together in a box and sold them, it was unlawful. So the common sense in me said, why are we doing this? We've had enough to do, so I just want to repeal it, and that's what this bill does. And I'll take any questions from those who want to ask.
Any questions from the honorable senators? Seeing none at this time. Thank you, Senator French.
Thank you. Cameron, could you call the first?
Sure. So first is going to be Sean Locke from the Attorney General's office. Sean, you should be able to unmute yourself.
Hi, can you all hear me?
Yes, we can. Thank you.
Excellent. So my name is Sean Locke. I am here on behalf, I'm an Assistant Attorney General. I'm here on behalf of the New Hampshire Department of Justice. I will say, in case questions come up along this line, I'm also here with Senior Assistant Attorney General Brandon Garrod, who's the Director of our Consumer Protection Bureau. So if there are questions about the Consumer Protection Act, he'll be here to help answer those. But I know Senator French, you and I have engaged before in the past in the Judiciary Committee, but for those of you who don't know me, I am the Director of the Civil Rights Unit here at the Department of Justice. Before that, I spent 5 years as a prosecutor in the Criminal Justice Bureau. And so just to kind of give you that way of background, the Department of Justice and the Attorney General himself opposed this legislation. Last session, we supported House Bill 1495, which was then rolled into House Bill 705 that established this prohibition on the sale of over-the-counter rape test kits. The sale and the use of over-the-counter rape test kits greatly jeopardizes the investigation and prosecution of sexual assaults. I cannot think of any context, either in a civil or criminal proceeding, in which a trial court would admit evidence gathered with such a kit. There would be questions related to the chain of custody, essentially meaning, how the evidence came from the victim to be presented in court that day. The normal chain of custody, the sexual assault nurse examiner would gather the evidence, make certain certifications and notations on the kit itself, turn that over to law enforcement, and there would be a tracking from the minute the victim comes in, the evidence is gathered through to its introduction and use at trial, through any testing of DNA or drug material or for DNA or drugs, or anything along those lines. So there'd be a clear line of how the evidence went through the process that wouldn't necessarily exist with these kits. So questions related to the chain of custody and also questions of tampering that would arise. If these kits are used in the privacy of a person's own home with no other witnesses, no one else around, there's always going to be the question here of, where did this evidence come from? Is this even evidence of sexual assault? And so even if this evidence were admitted, and the off chance it were admitted, the evidence and any victims would be subject to withering scrutiny by defense counsel and likely allegations of falsification. Victims of sexual assault already undergo tremendous scrutiny in a sexual assault case. And that's even assuming they do everything, every step, they take every step that, people would recommend you take as a victim. You will be subject to withering scrutiny. It will only increase when you introduce a kit that could be subject to allegations of tampering or falsification. And to assist sexual assault nurse examiners and law enforcement in the gathering of evidence, the Department of Justice produces kits for use by trained personnel and under appropriate protocols that the Department of Justice works with individuals from across many different disciplines in the state of New Hampshire and around the country to develop appropriate protocols for sexual assault nurse examiners and for the gathering and preservation of evidence in sexual assault cases. That material that may be gathered includes biological material, photographic evidence. It could include blood or urine samples if there are allegations of perhaps the person was drugged. It includes clothing, bed sheets, could be upholstery from a car or piece of furniture that all have to be gathered and preserved under appropriate conditions for, it could be months, it could be years until the victim is ready to come forward. They also have the opportunity for victims to come forward anonymously and receive anonymous rape test kits that will only be, the person who was subjected to the anonymous rape test kit will only be kind of disclosed or revealed when they choose to come forward. So a victim can remain anonymous until they're ready to come forward. And these protocols account for questions like chain of custody and control. And one of the most tragic outcomes that would come from a victim using one of these kits is the failure of a prosecution because the evidence gathered as a result of this kit becomes inadmissible. The only thing that could be worse is then a person who's been acquitted or charges have been dropped against them has the opportunity to commit another sexual assault because this evidence was lost. And as I said, I'm happy to take questions from members of the committee. And as I said, Senior Assistant Attorney General Garrod is here if there are questions that arise related to the Consumer Protection Act.
Thank you. Start off with my questions, I guess. So in the acceptable rape evidence kits that are administered by hospitals and police departments, what exactly do they contain?
So they contain a host of material, and I'm sure there are people, I don't want to get too far into this. This isn't, performing one of these exams is not my area of expertise. So I know there are probably people who will testify who can give greater detail than that. But among other things, I mean, there's material to gather evidence and contain and store evidence, but there's also information related to resources for victims and how they might be able to seek kind of crisis services, counseling services to assist them in the wake of the sexual assault that occurred. There are instructions for the individual gathering the evidence. Actually have a kit here so I can open it and take a look inside and see what kind of additional material it may have. But it's basically designed to give the overview, but it doesn't necessarily contain everything. So for example, it doesn't contain a cup to take a urine sample or vials to take a blood sample. That would be stuff that would be performed with the equipment the hospital possesses. But it includes generally a lot of material to kind of contain, and whether it's paper bags, plastic bags, things to kind of contain and hold the evidence that's gathered, that's all kind of safe from tampering. The materials in terms of kind of like things like tweezers or things like that may be used to actually take the evidence from the victim would be stuff used by the hospital.
So normally a lot of rape victims do not seek medical treatment immediately, nor report the crime. Isn't that true?
My understanding is the statistics are that sexual assault is an underreported crime. Again, I imagine Lynn Shillette will be testifying, and I'm sure she or someone from the coalition, and they can probably give you far more accurate numbers than I can. But yes, I do understand that sexual assault is a fairly heavily underreported crime.
And it being so underreported, how would the evidence remain untainted for days, weeks, or months if the only way you could maintain that evidence is by going in and reporting it?
So there are two kind of answers to that question. I think the first is always the fact that a victim can go anonymously if they do not wish to be disclosed or identified yet, and have the evidence gathered. But the other is sometimes, you know, in my role as a prosecutor, I mean, there were many cases where evidence hadn't been preserved either because the victim came forward months, days, or years after the sexual assault occurred. And that was fodder for examination of that victim. But in terms of one of these kits being available for an individual to gather the evidence on their own in the privacy of their own home, I think the way these kits are marketed is a tool to kind of empower victims so they can gather evidence themselves and collect things or come forward as they're able. The problem is that kind of hope, it really presents a false hope, because what happens is you've gathered the evidence and then it's essentially useless because a court, setting aside even kind of questions of if you have to store certain biological material for months, days, or years, the cost of doing that, the cost of having material tested for DNA or drugs, it's not, if it's not gathered through one of these kits, it's not necessarily clear what process a victim would have to go through and what cost a victim may have to encounter in order to have those kits, the material from those kits tested. Let alone, again, that's even before you get to the question of any of that being admitted at trial. And then you have a victim who thought they were empowered by purchasing one of these kits and gathering the evidence themselves, being told everything you gathered can't be introduced at trial, and we may not be able to go forward with this prosecution.
And it's up to the judge to determine whether or not something is okay to put into the trial, admissible. Has there ever been in the state of New Hampshire a judge that threw out evidence collected months before or brought in, such as clothing that may have been sitting around for a month or two in the victim's home, and thrown it out as evidence?
I'm not aware of a case off the top of my head of anything like that happening. I'm also not aware of how common it would be for material like that to be brought in so far past the date of the sexual assault, where it would be able to be tested or screened by the state lab. Certainly it could be possible that would happen, but I imagine that the more time that passes, the more difficult that becomes to do.
Right.
And so yeah, I can't answer that kind of with a clear case or a clear example that I can think of off the top of my head.
Great, thank you very much. Any questions from the committee? Senator Gannon.
Yep, thanks for taking my question. Senator French covered a lot. Again, did you have any cases where they've denied home rape kit tests, or they've admitted them?
So I am not aware of any of these kits yet being sold or used in cases here in New Hampshire. So we haven't had an example of one of these coming into, or this issue arising here. I believe at the testimony last year on House Bill 705, there was an example of a case in California from, I think, early during the COVID period, where one of these kits was administered, but it had what I'll call a fairly unique factual scenario, because the officer brought the kit to the victim's home, waited outside the door while the victim performed the kit on themselves under the supervision of a sane nurse who was participating via Zoom or WebEx or something along those lines, and then gave the material that was gathered in the kit to the officer who had been waiting outside the door. So it kind of helped alleviate some of those chain of custody issues that I kind of described. But that nothing about that particular case or that I'm aware of suggests that that's the process or the normal process that these do it yourself rape test kits would follow.
Follow?
Go ahead.
So in the rest of the country where the kits are sold, is it predominantly that the judges excluded, or do they seem to go case by case and listen to the evidence to decide a factual determination to admit or not admit the kit?
As I said, I don't know if I have a clear answer to that question at this time. We're not entirely certain how widely distributed these kits are, because I know many states, not limited to New Hampshire, whether it's they've banned the kits or I know a prominent example being New York's Attorney General issued a cease and desist letter. So the company is producing these kits to order them to stop distributing them in New York. But my understanding is kind of these kits are early in the production process. It isn't something that is necessarily a developed industry that is widely distributing. So this is kind of a prophylactic measure rather than a reactive measure.
Thank you.
Thank you. Any other questions? Seeing none, thank you very much for your testimony.
Thank you all.
Cameron?
Okay, Senator French, Representative Maria Perez has her hand raised.
Sure, let her in.
Okay, Representative, you should be able to unmute yourself.
Thank you for giving me the opportunity to speak up against in opposition of Bill 65. I'm representative from District 23 in Milford, but today I'm speaking for me as a victim of rape. This is a difficult subject for me to speak up, but I think and I believe it's necessary for me to speak up. It happened to me when I was 5 years old, the first time when it happened. And the reason that I'm speaking up today is because for me, it's very difficult to understand how can we get these kids and do it at home when someone related to you or someone from your family, a family member is the one is committing the rape. And in my culture, it's very difficult for family members to speak up or to be able to open up and then say exactly what's happening to you. So for me, it's very difficult to understand how can we do this kid when someone related to you is the one is causing the damage or is hurting you or is committing this. Like I say, it's very difficult for me to to talk about this, but for me as a victim, it's hard to understand how can we get evidence when most of the time when it's someone related to you is doing that. In my culture, we stay quiet, we don't say anything. And to be honest, I don't feel like this is going to help us. This is going to make us like don't speak up and then stay quiet harder than before.
Thank you. Any questions from the committee? Thank you for your testimony today. I'm sorry for your past problems.
Okay, Senator French, the next person on my list is Alexandra Azro. Alexandra, you should be able to unmute yourself.
Hi, yes, thank you. So my name is Dr. Alexandra Azro. I am a board certified emergency physician from Illinois. I received my Bachelor of Science from Brown University and my MD from the University of Illinois. I am a clinical assistant professor of emergency medicine at the University of Chicago Pritzker School of Medicine. I am a fellow of the American College of Emergency Physicians, and I'm also a Fulbright Scholar. I'm here today to explain my position in favor of SB 65, the bill aiming to repeal New Hampshire's previous bill banning the sale of at-home sexual assault kits. Those who support the ban of at-home sexual assault kits rely heavily on the hospital emergency department in order to make their case. They state that the emergency room forensic examinations are free of charge and that medical professionals with experience should be the ones to conduct these crucial examinations. I'm here today to describe to you, as someone who works in an emergency department every single day, why this defense is flimsy at best and what the actual reality of the process of completing a rape kit in the emergency department looks like. The emergency room process for dealing with sexual assault victims causes strain not only to the victims hoping to receive examinations, but to the emergency department personnel who manage these situations. Patients are registered with the emergency department, and because we work with a triage system, sometimes must wait an extended amount of time to be evaluated while already in a vulnerable condition. It may be hours before a sexual assault advocate becomes available to assist the patient, which is required before a sexual assault evaluation can even begin. As the physician, other than in cases of serious life-threatening injuries, I have to wait to fully examine an injured victim until the advocate is available and certain evidence has been collected. If they have further injuries that need attention, this process will prolong their visit significantly. This may be further protracted due to COVID-19. At the risk of sounding terse, hospital emergency departments are not always designed to handle sexual assault victims in the most sensitive and comfortable way. This is not to say that we do not want to help these people. We absolutely do. But we are designed to evaluate and treat life and limb threatening conditions in the most efficient way possible and move on to the next patient. There are always many people waiting to be seen with an array of urgent and critical conditions. This often does not translate to a comfortable, sensitive environment, which can then re-traumatize the already traumatized victim. We are at the front lines here to save lives, yet as I'm sure you know, we are already often minimally staffed or understaffed. When a nurse is assigned to a sexual assault patient for their exam, they must remain in the room with the patient for the entire visit, leaving the department short yet another nurse for an extended period of time. Additionally, many times it is not a sexual assault nurse examiner, but a normal registered nurse without this certification conducting forensic examinations and following unfamiliar instructions, as in many cases, a sane nurse is simply not available. Sane or not, with or without formal training in forensic examinations, a document with instructions is being followed in order to conduct an examination by a nurse who in some cases may have never done this before. So I ask you this, is it not the case that a victim of sexual assault, someone who is being examined with the goal of collecting forensic evidence for later use, regardless of training, may be even more vigilant in doing so because victims have a stake in the matter? They have personal motivation to carefully and completely follow the instructions, and therefore there should be no reason that victim collected evidence cannot be just as, if not more carefully and accurately collected as in the emergency setting. Once a kit is completed, it is placed in a box with a handwritten document of what injuries and physical exam findings were found, closed with a seal, which is a piece of tape, and signed by the nurse and physician. This signature represents legal documentation that everything collected was as documented. This can just as easily be done by the victim using their signature as their legal statement that what they've documented is accurate, as we do in the medical setting. They can then bring it to any approved drop-off site, and the chain of evidence is maintained and continued. If they further desire blood or urine testing, which is not a standard part of the kit, post-exposure prophylaxis, or any other medical needs, they can then seek medical care from their primary doctor, an urgent care clinic, or of course the emergency department after they've completed the kit, without having to wait multiple hours for a sexual assault advocate and minimizing the time and risk of repeat trauma to them. I support SB 65 because I believe that at-home sexual assault examinations had the potential to ease the burden on both sexual assault victims and hospital emergency departments. I also believe that having access to such an option would make it easier for a victim who may not have reported the assault otherwise to feel more empowered and comfortable to do so. The emergency department is a very daunting place. It doesn't negate the option to seek a kit being completed in the emergency department, just provides another choice. It is unfortunate that we must weigh the needs of victims against the needs of patients whose lives hang in the balance. But emergency rooms are tailored to saving the lives of the critically injured. We are already struggling to do this in the presence of COVID-19 and with a chronic shortage of staffing. If victims are critically injured, they should indeed visit a hospital. But those who experience sexual assault and simply require an evidence collection kit deserve an option such as this that may be less traumatizing, less time consuming, and more comfortable for them while maintaining accuracy and avoiding unnecessarily utilizing already overextended emergency resources. Thank you for your time.
Thank you. Are you aware that there are kits, the kits that I'm aware of that we banned last year consist of an intake form, instruction manual, paper bag to put the garments so you don't have to go to the hospital in the same garments that you were attacked in, a vial of distilled water, a large paper bag, 3 sets of cotton swabs, tape to seal the box, and a plastic box to put the swabs in to be sealed. That is what these consist of. Were you aware of that?
Yes, and those are all common items that can be found at any pharmacy and is actually very similar to the kit that we use in the emergency department as well.
And just to follow up, so where most assault victims don't seek help immediately, do you think it would be wise for them to have these at their disposal if they wanted a paper bag to put their garments in and cotton swabs to collect any kind of evidence that they don't wash off over the days that after they've been attacked before they seek help?
I do think it would be a good option to have, because about 77% of people who have been sexually assaulted don't ever report it. And I think not having to, get yourself up to go to check into an ER, and a lot of people don't know if it's going to cost them money, what's going to happen, how it's going to feel. I think having this and being able to do it at home would encourage more people to report and to collect that evidence that maybe, they might wait 2 or 3 days before they come to an ER because they're scared. And then you lose that opportunity that could have been done if they had this option immediately to just go buy one of these kits and do it at home right away.
Thank you. Any questions from the committee? Senator Gannon.
Yep. Thanks for taking my question. Just a quick question. Did you say these kits are available in your state or not?
I think they're not available here yet, but I think it's a question because it's a relatively new thing that it's being discussed in many states. So I don't think it's available here yet, but it is something that I'm in favor of.
Thank you.
Anyone else? Thank you very much for your testimony. Cameron?
Okay, next is Chief David Goldstein. You should be able to unmute yourself.
I think I did. Did that work?
Yes, it did, Chief. Welcome.
Fantastic. Thank you. Good to see you, Senator.
You too.
To Senator Gannon's point, sometimes I wish I was a simple country lawyer. But for the record, and good afternoon, Mr. Chairman and members of the committee. My name is David Goldstein, and I am the Chief of Police for the City of Franklin. I've been a police officer for more than 41 years. For 23 of those 41 years, I was a member of the New Hampshire State Police. For approximately 12 of those 23 years, I was assigned to the Major Crime Unit. My primary responsibility was what is today known as crime scene investigation. I was certified as a crime scene analyst by the International Association for Identification, which is a world-recognized organization responsible for certifying forensic experts. In addition, my skills as a crime scene specialist have been recognized in district courts throughout the state. I've been certified as an expert in crime scene investigation in the Merrimack County Superior Court as a result of the Colbert family domestic mass murder in 1991. I'm here today to testify in opposition to SB 65 for the New Hampshire Association of Chiefs of Police. The Chiefs of Police are deeply committed to ensuring the safety of all victims of domestic and sexual violence, and we are just as committed to our responsibilities to investigate such offenses. These for-profit kits provide a false sense of security for those who have experienced sexual assault. It is of tantamount importance that the chain of custody be protected in evidence collection for both defendants and victims. In fact, evidence handling is oftentimes recognized more readily by triers of fact than testimonial evidence. These kits are not viable alternatives to legitimate forensic evidence collection. I'm unable to envision a scenario in which such evidence, and I put that in quotes, collected from do-it-yourself kits would ever hold up in any court of law in New Hampshire. The Chiefs join with the professionals and advocates to encourage all victims to seek medical assistance and support from crisis centers after any sexual assault, whether or not they decide to move forward with a report to law enforcement. In closing, therefore, I ask that you find SB 65 ITL. Thank you for your consideration, and certainly happy to answer any questions.
Thank you, Chief. Chief, if you were investigating a shooting and you collected all the evidence you could, and before it went to trial, some neighbor came by and said, "Hey, I found this gun and shell casings next door. They belonged to the guy who was my friend. I wanted to turn him in. I have reason to believe he was the one who did the shooting." Would that gun and shell casings be evidence before the court, or would the court throw it out saying the chain of custody wasn't proper?
Well, certainly, I would hope that we would have found that evidence because we're very complete in the way that we do those investigations. But
Well,
understanding.
Franklin is, of course, but
I'm sorry?
Franklin is, of course, but others might.
But to answer your question as you put it, certainly we would take it, we would document it, we would photograph it, we would take a report on it as to where it was found. Certainly interview the individual or individuals who found it and opted to turn it over to us. We would try to introduce it in court through the prosecutorial body, whether it be the county attorney or the AG, depending on the level of the crime. And then it would be up to the court to attribute whatever weight it saw fit.
So same with these rape test kits, it would be up to the court to determine what weight to put on it, correct?
Absolutely. The point that I think I was trying to make, or I hope that I was able to make, is the fact that there is virtually no chain of custody there whatsoever. And we obviously look for that in virtually everything we do. Quite frankly, a lot of the investigations now have come down to that. Testimonial evidence is certainly questionable, whereas scientific evidence, which this becomes, is less so.
Great, thank you. Any questions from the committee members? Senator Gannett?
Thank you, Chief. In a perfect world, I would want everyone to come forward and go to the hospital and be tested. And I think that would be the ideal situation. But whereas the last doctor just testified that almost 80% of victims aren't coming forward in a timely manner to get that clean evidence, isn't it better to have something that a judge could decide the admissibility on his own rather than have 80% of the victims have no evidence?
Well, I think, as you well know, Senator, it's not just the judge. Certainly the defense counsel would have a great deal to say about that, and he or she would throw as many darts at the evidence as they could before it even made it to that point. So I can certainly envision the motions that would be heard pre-trial just to try to get the evidence in. If we could see some research that said that that might be a viable alternative, I'd certainly be in agreement with that. But quite frankly, what we're seeing here is this is a social and a psychological issue that goes far beyond just taking a kit and then hoping that it gets heard by the court. We are still not very supportive of our victims. We still have a great deal of difficulty understanding some of these things, and certainly defendants have a great deal of investment as far as their rights are concerned. So we've got a long way to go before I think that's kind of a viable argument, with all respect.
Thank you.
Anyone else? Thank you, Chief. Appreciate it.
My pleasure. Thank you.
Cameron?
Okay, next is Mark Beards. Mark, you should be able to unmute yourself. I'm sorry if I pronounced your last name wrong.
You got it right. Can you hear me?
If we can, go ahead.
Okay, good afternoon. My name is Mark Beards. I'm an attorney working with Leda Health and speaking to you today in support of Senate Bill 65 as an attorney. My practice is focused on criminal law, and I've worked on both sides of the fence, both as a prosecutor and defense attorney. I would like to respond to some of the comments in opposition to this bill and in support of the ban of over-the-counter rape test kits. There appears to be this misinformed contention.
Sir, you're getting feedback.
A foregone conclusion that evidence collected by. Okay. There appears to be this misinformed contention that it is a foregone conclusion that evidence collected by these kits would not be admissible in a court of law. I believe such a contention is not supported by New Hampshire's rules of evidence nor case law. In fact, it is likely that such evidence would be admissible. First, though, I would like to remind this body that Leda Health does not represent to its customers that such evidence will necessarily be admissible. Such a conclusion is made on a case-by-case basis, and the trial judge has wide discretion in making decisions regarding admissibility of evidence. That being said, a trial judge is instructed by New Hampshire's rules of evidence, which plainly state that all relevant evidence is generally admissible. Certainly, evidence collected by a complaining witness is relevant. There's been no argument that DNA evidence collected after a sexual assault is not relevant. Instead, the argument focuses on this talismanic phrase, chain of custody. There's nothing magical about chain of custody that requires it to be established by hospital workers or law enforcement. Further, any defects or alleged defects in a chain of custody go to weight and not admissibility. Chain of custody is actually a consideration under Rule 901 of New Hampshire's Rules of Evidence. This rule is concerned with authentication and identification of evidence. Plainly stated, it means that someone introducing evidence merely need to show a rational basis that the evidence is what the proponent claims it is. Now, this is a very low standard and can be accomplished through testimony of the complaining witness and a description of how they collected the evidence, as well as testimony of a laboratory official of how they received and processed this evidence. The jury is then in a position to make a determination as to what weight they will give this evidence, but the trial judge is strongly discouraged from withholding this determination from the jury. The ban on over-the-counter rape test kits is essentially making a legislative decision that juries won't believe survivors or that survivors are not credible witnesses. I believe that the ban on over-the-counter rape test kits is based on a misunderstanding of evidentiary law. There is no rule of evidence that would necessarily make such relevant evidence not admissible. Thank you.
Thank you. Any questions from the committee members? Seeing none, thank you very much. Cameron?
Okay, the next person I have is Madison Campbell. Madison, you should be able to unmute yourself.
Yep. Can everyone hear me?
We can. Welcome.
Okay, welcome. Thank you. Chairman Frank and members of the Commerce Committee, thank you for the opportunity to speak today. My name is Madison Campbell. I am the CEO of Leda Health. I am a sexual assault survivor, and I'm here to speak in support of SB 65. We want to start by reminding you of the 77% of sexual assault survivors who never report their assault, including my own story. With all due respect, the folks that oppose this bill today are the same people who fail 77% of survivors in the US who never report or go to the hospital. I would like you to let that sit for a moment. 77%, that means 4 out of 5 victims do not speak up, do not receive treatment, and do not even attempt to seek justice following their assault. It means out of a committee of 5, only 1 of you would go to the hospital or report your assault, and the rest would do nothing. At Leda, we do not accept the status quo as the only outcome. Leda's mission is to provide resources for survivors who do not seek traditional forms of help, not to profit, not to replace the existing system, but instead to support survivors. We believe this abject failure has led people in positions of power and decision-making to fear and hate even the ideas we promote, an additional choice where survivors have more rights, improved access, and are able to collect time-sensitive evidence faster, cheaper, and in a way that respects their privacy. These decision makers may tell you these kits are automatically inadmissible, which is more of a statement of their ignorance of the rules of evidence than their passion for helping survivors. They may purposely ignore examples of countries like Australia and Ireland and states like California, where self-use kits have been used without issue and have helped survivors who otherwise might have not sought or received the help that they needed. These decision makers also tell you after using our kit, survivors will not receive adequate Medicare that is vital for survivors. In the case of Leda Health, the point is misinformed. At Leda Health, we have forged relationships to provide access to resources for STI prevention and detection, emergency contraception, as well as group therapy for survivors to feel a sense of community while working through their trauma. They may tell you that, based on their ignorance, that you must assume that our team of survivors is selling false hope and profiteering off of survivors in their time of need. They ignore the fact that we're not selling any kits at this time. They have never spoken to us to learn how we have spent months developing clear disclaimers in compliance with current consumer protection laws while being trauma-informed. They may also tell you the risk of a new system, one where more survivors can make choices to help themselves. It's so dangerous that we have to ban a cardboard box that does not even exist at the moment. We are seeking a better system, one that deserves to be explored. Allowing these kits to be sold would be an opportunity to collect crucial data and determine just how viable the idea of self-collection is in practice. Whether the venture succeeds or fails is another story. The simple act of inhibiting an idea sends a dangerous precedent regarding the restriction of future ideas, a precedent that I'm sure nobody here is in favor of. At Leda, we want to fight for survivors, all of them, not just for the one who choose to or are able to visit a hospital. We will continue to fight for survivors. even if this bill fails, but passing SB 65 will go a long way towards that better system. And for that reason, I urge you to vote in favor of SB 65. I would be happy to answer any questions. Thank you so much.
Thank you very much. Any questions from the committee? Senator Susie.
Thank you, Mr. Chairman. You, in your testimony, you stated that allowing the kits to be sold would allow for data collection. Could you please elaborate on that? What data would be collected? Where would it go? And how would it benefit victims?
I believe that, one of the things that we'd be able to do is understand how at-home kits are increasing reporting. So if we work together with law enforcement, district attorneys, and, multiple kind of folks on the judicial side, we'd be able to understand if we're actually increasing reporting. And I think that that is a very important thing that we should look to do.
Thank you.
Thank you. Anyone else? Thank you very much for coming today.
Thank you.
Cameron?
The next person on my list is Janet Carroll. Janet, you should be able to unmute yourself.
Hi there, are you able to hear me?
We are, thank you.
Excellent. So good morning, Mr. Chair and members of the committee. For the record, my name is Janet Carroll and I am one of the Sexual Assault Nurse Examiner Program Directors at the New Hampshire Coalition. And I am here to testify against Senate Bill 65 to repeal the prohibition of the sale of over-the-counter rape test kits. I have been a registered nurse for the past 20 to 21 years and as a sexual assault nurse examiner since 2005. In addition to my role at the coalition, I am also currently the nurse manager of the forensic nursing program at Dartmouth Hitchcock Medical Center in Lebanon, New Hampshire. I'm board certified in both pediatrics as well as adult patient populations. I also serve as the co-chair of the New Hampshire Sexual Assault and Nurse Examiner Advisory Board, which is a statewide multidisciplinary team of professionals created by the Attorney General's Office to oversee the New Hampshire Sexual Assault and Nurse Examiner Program. The board consists of invited representatives from the Attorney General's Office, the coalition, crisis centers, medical professionals, SANE nurses, law enforcement, prosecution, forensic laboratory personnel, corrections, as well as many, many other disciplines. One of the things this board is responsible for is the development of the Attorney General's Sexual Assault Medical Forensic Examination Protocol. This protocol is critical as it governs the response of the medical and criminal justice systems to sexual assault victims. The guidelines presented in this protocol carry the weight of the law. When an adult patient presents to the hospital emergency department in New Hampshire with a complaint of being sexually assaulted, they are given the option of a medical forensic sexual assault exam with evidence collection and reporting to law enforcement, or a medical forensic sexual assault exam with evidence collection submitted anonymously with no report to law enforcement. And of course, they can always elect to not have any evidence collected whatsoever, that they're there for the medical care, the real reason that they need to come to the hospital. We believe in New Hampshire that we acted appropriately when we banned the at-home rape kits, and we oppose their use for the following reasons. One, the kits do not provide access to trained sexual assault advocates, a service currently available throughout New Hampshire. Mind you, their response time is generally within 30 minutes of a call from a hospital. Okay, so once they're triaged in New Hampshire, we call the advocate group and they should be there within 30 to 60 minutes, okay, depending on location. Two, the kits do not address the patient's health. The focus is strictly on DNA evidence collection. Evidence is only useful if a case proceeds to trial. The victim needs treatment, medical treatment. There are health consequences, both short-term and long-term, associated with sexual assault. Every emergency department in New Hampshire, all 26 of them, are prepared to care for sexual assault patients. I'd also like to mention that when they get brought into a hospital, when they present to a hospital, they are triaged at a level 2. On our system, a level 2, that is equivalent to chest pain patients, shortness of breath patients, so people having heart attacks, etc. Okay. The only patients that are placed ahead of them and being brought back into a room and being seen by the medical team are those where there's CPR in progress or trauma 9s where they're going to die. Okay. 3, the exam is conducted in a healthcare setting. The The exam conducted in a healthcare setting educates the victim about their options. As I mentioned, they can report to law enforcement. They can have evidence collected anonymously or reported, or no evidence collected whatsoever. 4, there are serious concerns about the admissibility of the kits in the court of law. The evidence should be subject to open discovery by defense counsel and likely fall short on many longstanding legal standards for admissibility in a criminal proceeding. Crime labs may have to place multiple disclaimers on any evidence collected, leading many courts to deny admissibility. Even suggesting to victims of sexual violence that they can collect evidence themselves and have that evidence be admissible in court is neither trauma-informed nor victim-centered. If anything, this leads the victim to believe falsehoods about what can be done with that evidence. 5, the state would lose the opportunity to identify serial predators and bring them to justice. When a survivor decides to allow their evidence collection kits to be tested and move forward through the criminal legal system, the state laboratory processes the DNA and enters it into the CODIS system. CODIS is a valuable tool that enables federal, state, and local forensic laboratories to exchange and compare DNA profiles and link serial violent crimes to each other and to known offenders. We know that many people who perpetrate sexual violence have multiple victims. When we bypass this process and send the evidence and data collected to the independent lab, that lab may not process any forensic evidence and furthermore may not be entering the evidence collected into these forensic databases. This in turn will leave our communities more vulnerable and actually limit our abilities to bring these perpetrators to justice. 6, the current statute only prohibits the sale of at-home kits to the general public. Current New Hampshire law prohibits companies from selling their at-home kits directly to a consumer and packaging it as a valid forensic evidence collection tool. There is nothing preventing these companies from going through proper channels to try to sell their product into the state of New Hampshire. If the product is innovative, can provide value to the state, and is manufactured at a lower price, then they can bid during the RFP process for their kit to be used at hospitals and child advocacy centers in the state. However, we cannot support the efforts of companies to charge rape victims for forensic evidence collection when these kits in the essential medical care is offered free by the state. Currently, they'd have to pay for these kits where the state provides them for free. It is important to understand that these kits will be sold without benefit of advocacy, nurses, or doctors to actually provide options and care to sexual assault victims, and with a promise of admissibility that simply cannot be truthfully made. Health systems are built to continue their care to all patient population, even with a pandemic in play. Patients suffer from heart attacks, motor vehicle accidents, gunshot wounds, kidney stones, other serious infections, and they're still being treated for and cared for in the emergency departments across the state. This bill will allow for the focus to remain on effectively treating patients who have experienced sexual violence and assisting them on their road to recovery. As forensic nurses, our primary concern is the patient's health care, medical care. We want victims of sexual assault, regardless of their desire to report the crime, to be able to seek care without fear and have evidence collected that will be admissible in court should they decide to report their crime. Thank you for your time, your considerations, and of course, I'll be glad to answer any questions. Thank you.
Thank you very much. Just a couple of questions from me. If an assault victim came to your hospital, say 5 days after the assault, would you get advocates for them there and do a health check on them?
Yes, absolutely.
That would be your primary concern at that point, right?
Correct. Their health care is our primary concern.
Right. So if they brought in a paper bag with their garments and a plastic box with swabs of evidence, would you throw that away or would you save it? Because it's been 5 days and they've changed their clothes, they've showered several times, they did collect this. What would you do with that?
So if they said it was from the time of the assault, I could prepare it and send it along. What the crime lab does with it and what police would do with it and whether it would be admissible is not of my control.
Right. So you also mentioned the state provides these kits for free.
Yes, we do.
And that if this company wanted to competitively sell them, it was more of a price issue with you, where the state and the taxpayers pay for these for free. Why should anyone be allowed to sell them? Did I get that from your testimony?
So currently, if a patient goes to the emergency department anywhere in the state, all of their sexual assault care, the entire visit, any laboratory, any medications that might be given, that's all for free to the patient. Where if they go to a pharmacy to pick up this kit, they're going to have to pay God knows how much to get that.
So it's a matter of price or viability?
Both.
Thank you. Any other questions? Seeing none, thank you very much.
Thank you.
Cameron?
Okay, the next individual on my list is Stevie Klein. However, I don't see them on the list. If they're on the phone, if you dial *9, that'll raise your hand. In the meantime, I will move on to the next person, who is David Conway. David, you should be able to unmute yourself.
Okay, you can hear me?
We can. Thank you, Doctor.
Okay, thank you, Senator French and the rest of the committee for allowing me to testify. I'm a semi-retired board-certified OBGYN, currently only working at the VA doing a GYN clinic. I'm also the president of the New Hampshire Board of Medicine, although I'm not testifying for the board. I am testifying in opposition to this bill. As a resident, and this is going back to 1986, 1990, at a large general hospital in Hartford, Connecticut, Hartford Hospital, a 1,000-bed hospital, GYN residents were responsible for examining rape victims. I will tell you that no rape victim wants to be in the emergency room, seeing a strange doctor, recounting the account of the attack, and having an examination. No one. What's the purpose of that? The purpose of it is to examine the patient, make sure that there are no injuries that may be life-threatening, and I've seen life-threatening injuries, as well as to collect evidence. And I've heard very, very powerful testimony today from both sides of the question. And I'm not a lawyer. I've worked with law enforcement individuals who have really emphasized the importance of a chain of custody of evidence. So for those reasons, I would be in opposition to the bill. I'd be happy to take any questions.
Thank you, sir. It must be very traumatic doing those examinations or having them done. And as you stated, no one wants to go there and do it. And actually 77% of victims don't do it. Why would you object to the collection of evidence in the privacy of someone's home?
I think that would be ideal. And it would take really a transformation, I think, of the legal system as far as guaranteeing that evidence would be acceptable. I think that if there are questions of it being acceptable, I think it's inappropriate.
Thank you. Thank you.
Mm-hmm.
Any other questions? Seeing none, thank you very much, Doctor, for your time.
Okay.
Cameron?
Okay. The next person on my list is Shelby Houghton. Shelby, you should be able to unmute yourself.
Hi there. Are you able to hear me?
We can, thank you.
Awesome. So good afternoon, Mr. Chairman and members of the committee. My name is Shelby Houghton and I'm from Milford, New Hampshire. I've worked with teens and abuse survivors at the Boys and Girls Club of Souhegan Valley for over 5 years. I'm currently a college student pursuing a degree in political science, human rights, and economics. And today I'm here to testify in opposition to Senate Bill 65. So this is my first time speaking before this legislative body, and I'm really grateful for your time. I've been following this issue for some time, and it is deeply concerning to me that young adults and college students like myself are being targeted by for-profit companies that use deception to sell a product to survivors of crime. College students are going to be most negatively impacted by this bill. If a college student is sexually assaulted, many will do just about anything to avoid going to the hospital. They would love to have a solution like DIY kits that suggest that you don't need to leave the comfort of your home. These are the people that will be vulnerable to this false sense of a solution to crime. These young adults will also have a harder time receiving medical attention, STI testing, mental health services, and advice from trained medical professionals and criminal professionals without turning to the resources provided to them through public health initiatives. I found that the reason why survivors do not visit a hospital or report to police for a rape kit is not a lack of access, but rather stigma and community pressure to stay quiet. This is also due to short civil and criminal statute of limitations for assault and rape, disbelief and doubt of survivors, and various other factors. Most recently, I was listening to the hearing in Utah, where the legislature discussed banning these kits just as they did in New Hampshire last year. And Leda Health CEO testified that, quote, the bill New Hampshire voted to pass last year was put in place by malicious actors with one attempt to stifle innovation and ban an idea. Due to the poor taste actions of the New Hampshire legislature, there is now a bill in the Senate, New Hampshire SB 65, to reverse HB 705 FN. Voting no on SB 65, or end quote, pardon. Voting no on SB 65 does not ban an idea, punish a business, or stifle innovation. It redirects energy to protect survivors and stops the deception a rape kit creates. Perhaps Leda Health does have the interests of survivors in mind, but their push for DIY rape kits does not act on that interest. Additionally, when Leda Health encouraged people to testify for HB 705 last year, their website stated, quote, we are here to tell you exactly what to say to avoid groveling with a New Hampshireite over the phone, end quote. Last week, Leda Health came under fire in the media after they posted an action alert in Utah that made it appear that their alert was authored by a rape crisis center, not them. Ultimately, this company does not care about New Hampshire rape victims. Leda Health was not fostered by New Hampshire constituents, and their efforts do not prioritize our state's overall well-being. They think we don't know what they're doing in New Hampshire, although New Hampshire has always been the leader on its response to sexual assault. I'm angered by the disrespect shown to our hardworking legislators and the lack of regard for the needs of survivors. There is nothing empowering about capitalizing on the very real fear, vulnerabilities, and trauma that comes from being a victim of sexual assault, which is an incredibly isolating and disempowering experience. I thank you for your time and consideration. I understand there are many other speakers in this session, but I ask you to please vote no on SB 65, and I yield to any questions.
Thank you. Any questions from the committee? Seeing none, thank you very much for your testimony today.
Okay, the next person on my list who I see is here is Jide Lin, and I'm sorry if I mispronounced your name. You should be able to unmute yourself now, though.
Hi, good afternoon. Can you hear me?
Yes, we can.
Thank you very much, and no worries, Cameron. It's Jedi. My name is Jedi Lin. I'm a civil rights, constitutional, and commercial litigator, and I work with Leda Health Corporation. I'm speaking to you today in support of SB 65. I'll begin by addressing the concern that over-the-counter rape test kits provide false promises or false hope about the admissibility of information collected. This concern is valid. However, it is not a reason to outright ban the sale of the product. First, New Hampshire already has consumer protection laws that specifically address and criminalize unfair and deceptive practices in trade and commerce. Those laws are adequate, and enacting an additional ban on a single product is both redundant and overbroad. Second, I can only speak for Leda Health, but its product clearly and concisely informs survivors about what the product can and cannot promise to do. Let me read directly a bit from Leda Health's product, front and center in the kit. We cannot guarantee that any information collected will be offered, admitted, or relied upon in a court of law. The ultimate admissibility and reliability of the information that you collect through Leda Health services will be dependent on the specific circumstances of your case and applicable law, end quote. The product also provides survivors information about how to report a crime, get medical help, and seek counseling or mental health services. Use of the product does not preclude the survivor from pursuing other means of information gathering. In fact, it is encouraged. If survivors are presented with this kind of information, then still banning the product says to me that the lawmakers of New Hampshire do not trust or think survivors are autonomous enough to make decisions for themselves about what they do with their own bodies. and that is quite troubling to me. Third, going back to the concern about false promises or false hope, I urge you to compare that concern with the actual language of the ban. They do not match. The ban says nothing about misleading information, marketing, disclaimers, or the like. It is just an outright ban on the sale of a product in speech regarding that sale. This is concerning to me in terms of overstepping into the rights and liberties of survivors and companies. Lastly, I ask you to consider this. In the very same bill as the ban on over-the-counter rape test kits, the legislator voted to eliminate the statute of limitations for certain sexual assault crimes, recognizing that in some instances, survivors do not take action or feel ready to report for months, years, or even decades. It is often not simple, intuitive, practical, or manageable for a survivor to go to a hospital or the police immediately following a sexual assault. In fact, studies have shown that approximately 69% of sexual assaults are never reported to law enforcement ever. In this reality, I urge you to repeal the ban that denies survivors options. Survivors should have the right to access, privately and on their own terms, information that is contained within their own bodies, be it for a civil lawsuit, criminal case, Title IX university action, or any other private reason that we may never know. It is not up to us to say why someone may want to access this information, but it should be up to us to recognize their right to do so. Thank you very much.
Thank you. Any questions from the committee members? Seeing none, thank you very much.
Thank you.
Cameron?
Okay, the next person on my list who I see is here is Andrew Livernois. You should be able to unmute yourself.
Hello, good afternoon. Can you hear me?
Yes, we can.
Good afternoon, Mr. Chairman, members of the committee. My name is Andrew Livernois. I am the county attorney for Belknap County. I'm a prosecutor here in New Hampshire. I've been the county attorney here in Belknap for since August of 2017. I'm a practicing litigator. I've been a lawyer for approximately 25 years. I'm a graduate of the Yale Law School. I'm here in opposition to this bill. And I believe that the ban, which was enacted in 2020 on these products, was wise and appropriate and should remain in place. And I oppose these home rape test kits because I believe they are misleading and provide false hope to sexual assault victims, and because I believe that the widespread use of these products will make it harder, not easier, for us to prosecute offenders who commit sexual assaults. And I would like to just point out first that I think it's important to keep in mind that this statute or this repeal that you're considering will not just apply to Leda Health. And so I don't think you should focus all of your attention on what Leda Health says that they will do or won't do, the disclaimers they do or do not put on their products. The lifting of this prohibition will open up the marketplace for other profit companies, profit-making companies to come in who may not be as enlightened as Leda Health. And my concern is that other companies will come along which will not be as careful as Leda Health says that they will be in this case. I will agree that there's a problem that we face in our society, that sexual assaults are severely underreported and that many perpetrators avoid accountability because of that. That's something that my office and all prosecutors around this state work very hard to try to fix. But my contention is that these products will not make that problem better. If anything, they're going to make it worse. They're going to make it worse because the person who has been traumatized and who is thinking about coming forward and is thinking about going to the hospital to get a SANE exam, which is the gold standard, right? It's the standard that's been set by the Attorney General's office. We have these carefully constructed protocols. We have a network of SANE nurses around the state who are ready to take care of victims. So you have a victim who's been assaulted and who's thinking about going to get a SANE exam, who's concerned about gathering evidence and is given this false hope, this option. Well, I can do this instead. I can do this at-home kit. It'll be almost as good. I'll get the evidence, and then I can make my mind up later about whether to go and report this. The problem is, A, The victim who chooses at that point not to go to the hospital will have given up the opportunity for the SANE exam and all of the other types of evidence that can be gathered in a SANE exam. Because it's important to remember that the DNA is only one small part of a SANE exam. You know, the SANE nurses do a head-to-toe examination of the victim. They look for any marks. They look for injuries. They take they document the existence of injuries. They interview the victim and get additional information about what happened to them. They look for hair information. They look for fibers. And in addition, they provide medical care, as you've heard, STD treatment, prophylactic birth control, all those sorts of things. So the person who chooses to do the at-home care instead of going to the hospital will miss the opportunity for all these other types of evidence collection. And then in addition, they will have gathered this evidence, which may or may not be admissible at trial, which may or may not turn out to be useful. And the concern about the admissibility of this evidence is not simply being raised by my office or by prosecutors here in this state. It's a national concern. The National Association of District Attorneys has raised a concern about this. Various attorney general's offices from around the country have raised concerns about this. Chairman French, you are correct that the ultimate question of admissibility of this type of evidence will depend on the judge, who will apply New Hampshire's case law and New Hampshire's rules of evidence. But I think there's a real concern about, there'll be concerns about cross-contamination. There'll be concerns about chain of evidence. There'll be concerns about the standards that these laboratories use, which won't be the laboratory that was chosen by the state. It'll be some other laboratory that we don't have control over. And here in New Hampshire, the judges are used to hearing about the evidence collection protocols and systems we have in place. They're used to admitting the DNA that's been collected by SANE nurses. So allowing these at-home rape kits will introduce all these other complications and factors, which will make it more likely that this evidence will not be admitted. So for all those reasons, we oppose this statute. And I'll welcome any questions you have.
Thank you. So as a prosecutor, if you had one of the 77% of women who've been accosted and a victim, one of the 77% that don't report it in a timely manner, if they were to come to you with evidence that they collected on their own, would you just throw it away and say, I couldn't use it? Or would you try to use it in a court?
No, of course, I would try to use it. And if these at-home kits were allowed, we would have a legal argument in court about whether they were admissible or not. But my preference would be that the victim go and get a SANE exam. And so by offering this alternative, you're discouraging the victims from going and getting the best type of evidence I could have.
So without offering this today, because this is not offered today, 77% of the women or men don't go.
But respectfully, Mr. Chairman, that's not why they're not going. It's not as though they're choosing not to go because they don't have an at-home rape kit alternative. There are lots of different reasons why people who are the victims of sexual assault don't come forward. There's the stigma of it. There's that sense of being traumatized and just wanting to be left alone. There's all sorts of reasons. And it's not as though if we made this an option, it's going to mean more people are going to come forward. I just don't think that's likely.
But you would use it if it was the only football you had to throw.
If it was the only evidence, yes, I would absolutely use it. And
okay,
we go forward on cases where victims don't come forward right away all the time. You know, I am constantly prosecuting cases where victims have not come forward right away. And we understand why that happens. But it's always better if you have a prompt disclosure.
Right.
It's always better if you have evidence that was collected in a controlled manner by a trained professional. And the same nurses I have worked with are terrific. They do amazing work and are very good at what they do.
Great, thank you very much. Any other
Thank you.
questions from the committee members? Seeing none, thank you very much for your time.
Thank you, I appreciate it.
Cameron?
Okay, the next person on my list is Jane Mason. Jane, you should be able to unmute yourself.
Okay, I just unmuted. Can you hear me?
Yes, we can. Thank you.
Thank you very much, sir. Good afternoon. Thank you for the opportunity to speak today, and thank you all for your service. I am in favor of Senate Bill 65 to repeal the ban of at-home evidence collection kits. My name is Jane Mason. As background, I am a retired FBI special agent with expertise in complex investigations and forensic evidence collection. After working with numerous sexual assault survivors, I created the Preserve Kit, the first at-home evidence collection kit for sexual assault survivors. I would be happy to submit to your committee my research that supports each and every claim I am about to make today. I want to point out that trial courts already do accept evidence saved by survivors. I also want to point out to the committee that, everyone seems to be focused on criminal cases, but evidence is also important and needs to be collected for civil and administrative cases as well. The New Hampshire Coalition Against Domestic and Sexual Violence has made several claims that I'd like to address. The coalition said, quote, "No reason exists to believe the evidence collected would be admissible in a court of law," close quote. Based on my 28 years of law enforcement experience, I say plenty of reason exists to believe the evidence collected would be admissible in a court of law. Crime victims don't magically taint their own evidence. In actuality, crime victims often have evidence to turn over to law enforcement. In turn, law enforcement begins the legal chain of custody when they collect it. The coalition said, in New Hampshire, survivors have a right to access a medical forensic exam for free. My response is that we are focused on helping the vast majority who do not come forward for an exam. That group of people, that group of crime victims deserve our help. If they do come forward and report at a time in the future, I am confident that law enforcement would work with those victims to have any costs incurred by them on at-home evidence collection kits to be reimbursed to those victims under the Crime Victims Compensation Act. The coalition claims these kits represent a false hope for justice. I believe nothing further could be from the truth. We know from talking with SANE nurses that survivors frequently bring evidence to sexual assault exams. I feel survivors should be able to collect evidence properly, whether they plan to take it to a SANE exam or whether they want to keep it at their homes in storage until some later time when they make a decision if they want to report the crime. The coalition never reached out to me to understand my approach to at-home evidence collection kits. No entity that offers resources to sexual assault survivors or other opponents of at-home sexual assault evidence collection kits ever reached out to me to this day. Instead, many of these entities espoused hostility and falsehoods against me, my company, my colleagues who believe at-home evidence collection kits are a revolutionary step forward in addressing the epidemic of sexual assault. Instead, their hostility hurt my professional reputation and nearly bankrupted me. The hard truth is that the vast majority of survivors do not report, and they deserve our assistance. Working together to help crime victims should be our path forward. Even as Senator French used an example, when a bystander finds a weapon and turns it over to law enforcement, it is scrutinized as any other item of evidence is and should be. Why do we exclude sexual assault survivors yet again from trying to attain some justice? To all my colleagues in law enforcement who testified earlier, I respectfully say that before saying the kits originally developed by me in 2019, I'm your colleague in law enforcement. Before you say they aren't viable, they wouldn't be admissible, I respectfully ask, why not work together with other experts on the best future for crime victims? Thank you very, very much for your time.
Thank you. Any questions from the committee members? Thank you, Ms. Mason. Cameron?
Thank you.
Okay, the next person on my list is Wendy Murphy. Wendy, you should be able to unmute yourself.
Thank you very much. Can you hear me?
Yes, we can.
Great. Chairman French and members of the committee, thank you for your time today. I'm testifying in support of SB 65, a bill that empowers survivors and corrects long-term problems with hospital rape kits. As you know, my name is Wendy Murphy. I direct the Women's and Children's Advocacy Project at New England Law Boston, where I have taught an upper class seminar on sexual violence law for 20 years now. I'm a former child abuse and sex crimes prosecutor, a former visiting scholar at Harvard Law School, where my work focused on injustices suffered by women in their capacities as victims in the criminal justice system. I've been working in the field of sexual violence as a civil rights and constitutional rights lawyer for more than 30 years. And I can count on two hands the number of cases where a hospital rape kit helped prove a case. I sat on the first ever SANE board in Massachusetts, where decades ago I raised concerns about the harm that was being caused by hospital rape kits, not only to women, but also to the integrity of criminal prosecutions. State crime lab officials provided data to our SANE board in Massachusetts showing that hospital rape kits were helpful only about 10% of the time and useless or harmful in the remaining 90% of cases. Defense attorneys love rape kits because more often than not, they contain information and evidence helpful to the defense. Allow me to explain two specific ways in which they are helpful to the defense and harmful to victims. And I'll also explain how at-home kits avoid these problems. I have two primary concerns. One, I will describe as over-testing, and two, the needless disclosure of irrelevant personal information. First, over-testing. This is what happens when kits are subjected to DNA testing, even when there is no need, which leads to the disclosure of irrelevant and deeply personal information, such as DNA from recent consensual sex partners. In 85% of rape cases, the defense is consent, meaning the defendant admits the act occurred. In these cases, no DNA testing should be done because the presence of DNA bears no weight on the only issue in dispute. Other needless disclosures occur with hospital rape kits because victims are forced to answer probing, irrelevant questions during the intake process. They are asked about past mental health issues, insurance information, workplace address, home address, medical history, personal physician information, and again, prior sexual activity. None of these things should automatically be disclosed in a criminal case, but they are mandatory disclosures for all victims who submit to hospital rape exams. Not surprisingly, needless violations of privacy are often cited by victims as reasons they decline to report rape or decline to stay involved in the criminal justice process after charges are filed. A recent case from New Hampshire illustrates my point. In State versus Shepard, which is a 2009 case, the court reversed a rape conviction because the medical professional who did the sexual assault examination at the hospital did not include privileged and irrelevant information about the victim's mental health in the rape kit report that was submitted to law enforcement officials and prosecutors. The doctor involved in the case believed this information should not have been turned over because it was confidential and unrelated to the exam. Other experts testified as well and made clear the information had no bearing on the rape case and that nothing about the victim's mental health issues affected her credibility. But the court ruled that the material had to be turned over to the defense nonetheless because it was part of the forensic rape exam process. The medical care providers who would ordinarily be ethically and legally required to protect patient privacy are now mandated to violate privacy because when they do these exams, they are considered state agents. So everything they gather, even if only for medical purposes that has nothing to do with the criminal case, becomes fair game and must be turned over to the defense. If the victim used an at-home kit instead of going to the hospital, she would not have been forced to endure these gratuitous invasions of privacy and would not be forced to choose then between justice and privacy.
Ms. Murphy,
Yes.
not to interrupt you, but we're running late with the hearings. Could you wind it up, please?
Yes.
Thank you.
Let me just skip ahead a little bit then. For sexually active women in particular, hospital kits are especially damning. They do have no choice but to submit to the testing of DNA that reveals recent consensual sex partners. This destroys rape shield laws by making all recent sexual activity fair game and relevant in a legal system that otherwise tells them rape shields will prevent the disclosure of this very information. At-home kits do not cause this needless over-testing of DNA. I'll just say two more quick things. As a former prosecutor, I can assure you that self-gathered evidence is admitted all the time in courtrooms every day in this country. As you pointed out, Chairman French, with the example of the gun found by a neighbor, maybe that's not quite the same as evidence gathered from inside a person's body, but the idea that at-home kit results won't be admissible because the evidence is gathered by a victim is simply false. There is no basis for that criticism. Lots of criminal cases involve evidence gathered by lay witnesses rather than the police or hospital personnel. It's quite common. I urge you to support this bill. I want you to know that the demand for these at-home kits emerged organically from a growing awareness that hospital rape kits, though they've been around for a very long time, have not been helpful except in rare occasions and are often harmful. We want to encourage reporting. At-home kits will encourage reporting, and I urge you to support this bill. Thank you for your time.
Thank you very much. Any questions from the committee members? Seeing none, thank you. Cameron, how many more speakers do we have?
I believe I just counted there are 5 or 6 left.
Okay, anyone wishing to speak? Glad to hear you. Please keep your testimony to 3 minutes or less and don't repeat what you've already heard. Call the next one.
Okay, the next person is Jennifer Pierce Weeks. Jennifer, you should be able to unmute yourself.
Good afternoon, Mr. Chair and members of the committee. Can you hear me okay?
Yeah, we can. Thank you.
For the record, my name's Jennifer Pierce Weeks. I'm the CEO of the International Association of Forensic Nurses. I've been a registered nurse for 35 years and a sexual assault nurse examiner since 1995. I'm here to testify in opposition to Senate Bill 65. We oppose it for the following reasons, some of which you've heard, so I won't be repetitive, but health and recovery of the victim is the primary concern of forensic nurses. In New Hampshire, a victim can go to any hospital, have an exam, including evidence collection free of charge, as you've heard. But the DIY kit, no matter who manufactures it, is not able to identify, document, and treat victim injury or prevent associated disease or pregnancy. That exam and treatment becomes part of the overall evidence at a criminal trial, assuming it goes there. This will actually reduce the number of people going to the hospital to seek care. So while I appreciate the premise being put forward here, that means now we have victims outside the window of pregnancy prevention because they don't come to the hospital. And it means outside the window of HIV prophylaxis because they don't come to the hospital. It means acquiring sexually transmitted diseases that then put them at risk for other things because they don't come to the hospital. So from my perspective, it's much more about health than it is about evidence and the admissibility of that evidence. Forensic nurses educate victims about their options. As Janet informed you, New Hampshire has many options, not including the anonymous evidence collection kit, but nothing is mandated of the victim. The victim gets to decide. The DIY kit does not contain everything needed. The New Hampshire Department of Justice provides sexual assault kits and the associated documentation that mirrors the New Hampshire protocol and expectations. The DIY kits do not. And the admissibility issue, I just won't even get into, you've heard enough of that. But one of the final fears that I just want to bring to your attention is that there are parents who are going to be concerned about their children having been sexually abused that believe that they could use this buy over-the-counter kit to prove the abuse and potentially even insert swabs into the vagina of a prepubescent child, wholly inappropriate given the differences in child versus adult exams. While we do believe the manufacturer's intention in creating these kits was without malice, we do not believe they will increase the evidence collection or reporting of sex crimes in the population currently not reporting. That will require extraordinary societal and systems change because victims tell us on a regular basis why they don't report. So going after those types of issues might be more effective. Thank you for your time and consideration. I'd be glad to answer any questions my testimony may have posed or any questions in general about this topic.
Thank you. Any questions from the committee members? Seeing none, thank you very much for your testimony. Cameron?
Okay, the next person on my list has just disappeared. Okay.
Nice.
The next person on the list is Craig Pritzky, who I did see a moment ago. Craig, you should be able to unmute yourself.
I'm here. Can you hear me?
Yes, we can, Craig. Please keep it under 3 minutes and welcome.
Yes. Thank you. Good afternoon, Senators. My name is Craig Pritzky. It's my honor to speak here today. I work with Lita Health. More importantly, however, I am a survivor of sexual assault. As a survivor of sexual assault, I'm uniquely qualified to speak to this matter. So please consider that. I'm a male survivor of sexual assault and abuse. There are more of me than you think, and kits like this aimed at empowering patients to take ownership of their healthcare and reduce stigma around coming forth are of particular importance to us in a society that mocks men like me. I understand this bill addresses a sensitive matter and therefore, like most sensitive matters, carries with it strong emotions. While the emotional rationale to approve Senate Bill 65 swiftly and decisively is undeniable, there's also an indisputable intellectual component that can't be overlooked. With the advent of COVID-19 and even well before that, we've seen an opportunity, if not an expectation, for people to take ownership of or at least proactively participate in their own healthcare. This has been true of everything from interaction with primary care physicians to execution of orders provided in connection with rehabilitation efforts, where those efforts were directed at physical health or mental health. As people have been empowered to self-direct their care, we have seen the setting of care delivery move from the sterility of a clinic to the safety of one's home. COVID-19 has mandated that, in many instances, this new healthcare delivery setting, once the outlier, has become the norm. In all forms of healthcare, we see patients empowered to treat their disease states in privacy with dignity and away from the judgment of onlookers. Great strides have been made to provide people with a safe space in which to receive care, but more remains to be done. Currently, mechanisms exist that allow people to collect blood samples at home, urine samples at home, and even take medication to address opioid use disorder at home. Unfortunately, no such mechanism exists that allows someone who has been sexually assaulted or violated to collect a DNA sample from the alleged perpetrator at home. We have heard countless stories of people who have not pursued care because they were afraid of the stigma and associated judgment that will follow an admission of being sexually assaulted. We have heard many people share their experiences of how the aftermath of sexual assault were more challenging than the violent act itself. We've left victims of sexual assault or sexual violence without good alternatives to speak their truth and seek justice. The availability of over-the-counter rape test kits provides the opportunity for people to whom there might not be an opportunity to overcome the trauma associated with a forensic exam and to take ownership of their own health. The availability of such kits does not obviate the potential for a survivor to later interact with trained law enforcement or healthcare professionals in the same way that a pregnancy test does not preclude a person from later seeing a doctor about their pregnancy status. We've learned that vulnerable patient populations need extra support provided to them. We know that providing vulnerable patients with safe spaces empowers them to acknowledge and address the challenging circumstances with which they are faced. And we know that it's good for long-term outcomes. I can think of no other population that needs this more. When people need to take medication to stave off cravings and triggers that portend substance use as they battle addiction, technology can be used in a video directly observed therapy where a person can, in real time, show they are taking their medication to a healthcare provider or legal official. I believe the same can be done for someone collecting DNA after sexual assault that will mitigate the necessity of having in-person oversight of such collection and empower people to commence collection in their own home. The opposition to such availability of over-the-counter rape kits assumes, as others have said, many bad things about survivors. I won't repeat those. But let me state the following, that the notion that kits are already paid for are available to all patients in emergency rooms free of charge is moot. The entire existence of such at-home kits for patients to collect evidence at home is what's at stake here. Cost and availability in emergency rooms should have no bearing in this dialogue. Frankly, I cannot even believe the cost factors into this dialogue. Earlier, we heard from a legislator who questioned the value of the availability of these kits in situations where some barrier, in her case it was culture, prohibited people from coming forward to address their truth and engage in self-care. I have no doubt that such obstacles exist. But for those who do not feel confident in using a test kit at home, do you really think they're going to feel confident in going to an emergency room or to a police department to tackle this head on? That's a much more overt measure. As we heard earlier, victims don't have many, if any, options available to them. It's incumbent upon us. We have a moral imperative to do this. And there's a current precedent in the relaxed delivery of healthcare we currently see in the world today to make these kits available to everyone and anyone who might want or need one. I urge you to join me in support of Senate Bill 65. New Hampshire's never shied away from doing what's right. You're the leader in the nation in important initiatives. This is another opportunity for the Granite State to show its strength of character, dedication to even-handed governance, and commitment to empowering people to take ownership of their actions. In this instance, the administration of their healthcare. Thank you for your consideration.
Thank you. Any questions? Seeing none, thank you for your testimony today.
Okay, the next person on my list is Harmony Reed. Harmony, you should be able to unmute yourself.
Yes, I have. Can you all hear me okay?
Yes, we can. Thank you for coming before us.
Wonderful, thank you. Good afternoon, Mr. Chairman and members of the committee. I just timed myself, so I'm a little bit under 3 minutes, so I should be good. My name is Harmony Reed, and I am a survivor of campus sexual assault and domestic violence. I am testifying today in opposition to Senate Bill 65. Last year, the New Hampshire legislature took great strides to protect the victims of sexual violence, and I am deeply concerned about this bill, which would set back the progress that was made just months ago. I'm here to briefly share my own story to demonstrate how important it is for sexual assault victims to be offered medically sound information following a traumatic event, and why the sale of fraudulent rape kits should not be permissible in the great state of New Hampshire. I had just turned 18 when I was sexually assaulted for the first time, and I remember the details and horrors that occurred that night in such clarity that I could recreate every color and scent for you right here, right now. But what I cannot recall for you is the countless steps that it took in the days, months, and years after to ensure my path to healing was safe and supported. While I learned of the effort to repeal the ban on the sale of fraudulent do-it-yourself rape test kits to the general public, I was genuinely horrified. It's alarming to think that New Hampshire would allow a for-profit company to sell lies to victims who so desperately need medically accurate information and support after experiencing a sexual assault. Sexual assault not only changes victims' lives, but it also affects every community. Without support and healing, victims are far more likely to experience mental health concerns, substance use disorders, chronic health issues, homelessness, and poverty. Sexual assault has lifelong impacts, and it's not a joke, but these kits are. These kits are being rejected across the country because they send the message you don't need support or medical care after you've been sexually violated, but you can collect your own evidence in the privacy of your own home. This is something that would have sounded pretty appealing to a college 18-year-old me and many other students who are experiencing the effects of trauma after assault. But the truth is, these kits are prepackaged lies that cannot be used by the criminal justice system. They can't refer a survivor to individualized services that they may need. They can't provide a survivor with sexually transmitted testing. And they can't help in stopping serial offenders from inflicting violence and pain on victims and communities. Please do not allow a company to profit off of the vulnerable. If the trauma of one individual funds the Christmas vacation of another, we are setting a precedent that the journey and care for survivors does not matter in the state of New Hampshire. New Hampshire is a state that believes in liberty, and the liberties that are stolen from sexual assault victims are so great that the state must step in and create safeguards against this abuse. I respectfully ask each of you to oppose this bill and ensure survivors in the state of New Hampshire feel the power of what it means to thrive. Thank you.
Thank you, Harmony. Senator Steve, any questions for Ms. Reed? Seeing no further questions, thank you, Ms. Reed, for your testimony. Cameron, can we move on to the next speaker?
So Senator Gannon, that is everyone who has signed up who I do see here. However, I'm just going to go over the list of folks who aren't here, and then if they're here, they can raise their hands.
Thank you.
We have Stevie Klein, Nikki Forday, Patricia LaFrance, Jalen Ortiz, Melissa Prefontaine, and Kaylee Gilbert. Those are the individuals. Okay, it looks like Nikki Forday has her hand raised, Senator Gannon. I'll bring her in.
Thank you.
You
Thank
should
you,
be able to
Ms. Forday.
unmute yourself now.
Hello, can you hear me okay?
Yes, we can. Thank you very much for coming today.
Hi, thank you very much. For the record, my name is Nikki Fordy. I am a resident of Litchfield. I'm also a social worker and a drug and alcohol counselor. I came to that job after experiencing trauma in my own life. I'm here to speak against SB 65. What I have to say is that I'm someone that has been sexually assaulted, and I also have, unfortunately, had the experience of having a rape kit done. And what I would say is that, you know, when you are raped, your body becomes a crime scene, and we should not allow any do-it-yourself interventions when it comes to a crime. Sexual assault victims are not inconveniences to emergency rooms, and what has occurred is an emergency regardless of the extent of any physical injury. As was suggested earlier, you know, seeking care from a primary care physician for things like emergency contraception, blood and urine testing, these things are very time sensitive. You know, in the event of a drug facilitated sexual assault, many drugs leave the system in less than 24 to 48 hours. This kit will, this so-called over-the-counter do-it-yourself kit will only encourage more people not to seek immediate help and to minimize the need for intervention and downplay the very serious nature of this crime. It is absolutely someone's choice if they wish to report to the police, but that's also a separate decision whether or not to receive the medical treatment and have a complete rape kit performed. When I was raped, I knew I needed to go to the hospital. It was lengthy, intrusive, terrifying, and there's no way I could have performed the kit myself. I don't think my hands stopped shaking until sometime the next day. I would not have been able to read and follow directions. Just in short, this exam is not simple and it should not be performed alone. The existence of these kits is dangerous. And when there are consumer products that are dangerous, the government should step in and ban them. New Hampshire did what was right, and we need to uphold the ban. Thank you.
Thank you, Ms. Forday. Does anyone have any questions for Ms. Forday?
Thank you.
Thank you, ma'am, for your testimony. Senator French, next
Thank
bill.
you, Senator Cameron. Next.
Okay, the next hand raised to speak for the first time is former Senator Bragdon. Senator Bragdon, you should be able to unmute yourself.
Thank you, Cameron. Thank you, committee. I'll be quick. I wasn't planning to speak. I hate to repeat something that's been said, but can you hear me?
Yes, we can. Go ahead.
Very good. I just want to, a number of people have brought up the issue of, by the way, for the record, I am a lobbyist representing Leda Health. And a number of people have brought up in their testimony this grievous thing that this is a for-profit company and making it sound like they're looking to take advantage of people. Let me just point out that the so-called free kits that are available from the state are made primarily by two companies. One is a multi-million dollar company that brags about their 125-acre campus. The other one is a company that brags that they were just purchased by a private investment company. So let's not kid ourselves that there's no money involved in this. And I think it's unfair to portray Leda Health in a bad way because they are a for-profit company. All these companies are for-profit companies. I just want to make that clear. Thank you, Mr. Chairman.
Thank you, Senator.
Okay, that's everyone to speak for a first time. Representative Maria Perez has her hand raised to speak for a second time.
If it's something new, we'll take her you get a couple minutes.
Okay, Representative, you should be able to unmute yourself.
Thank you, Senator, for letting me speak for the second time. I'm hearing everyone that is saying that victims don't speak up. I just wanted pointed that as a victim, I speak up. I was a victim of 3 sexual assaults done by family members. And the first time that it happened, I ran away. I went to a Catholic school. The second time, I was taken from the school by another family member and sexual assault me again. And that didn't, that happened again with another family member. So to be honest, when I heard people saying that these crimes don't get reported, I did report it, but my life was in danger. I was told that I was gonna get killed by a machete if I was like coming up in public and speak up against my mother's will. So to be honest, with all the respect, I don't think this home kit is gonna help victims when we have so many family members who, most of the time, the ones that are committing these crimes, and then a lot of times family members cover whatever these people are doing to the victims. So with all my respect, I will vote against this.
Thank you very much for your testimony. With that, I'm going to close the Senate hearing on Senate Bill 65. And if everyone's ready, we'll get through the next one. If you want a break, let me know. Okay, then I'll open Senate Bill 70. And Senator Kavanaugh, are you going to open up? I see Senator Sherman's here.
Oh, Senator Sherman is. There we go. I'll defer to Senator Sherman then.
Senator Sherman, yep, there you go.
Thank you.
Good afternoon, committee members, chairman. I am, for the record, Senator Tom Sherman, District 24, 11 towns on the Seacoast. And I am introducing Senate Bill 70. And I just want to give a very brief background on Senate Bill 70. This is relative to insurance coverage for emergency behavioral health services for children and young adults. Senator Bradley and I focused on the issue of ER boarding back when I filed SB 11 in 2019. And that was primarily focused on adults. In the child or pediatric population, SB 14, a huge effort by many, many people, was passed into law and signed by the governor to really address a system of care for children consistent with the 10-year mental health plan. And then along came COVID. And COVID has shown just how fragile the support is for children, whether they have Medicaid or whether they have commercial carriers. Last week, we averaged 30 to 35 children in emergency rooms across the state waiting for mental health services, sitting there in acute mental health crisis. In October, I had the incredible pleasure of meeting one such young woman who is here to testify today. And I was just blown away by her honesty and how much her need for adequate care and the unavailability of that adequate care impacted her and her family. So I've, along with Senator Bradley as a co-sponsor and effort with many other people who will be here to testify, we filed SB 70 to address one component of what we call in medicine a multifactorial problem. This issue of children sitting in our emergency rooms, not getting the care they need, waiting for a bed at Hampstead Hospital has got to be addressed. And SB 70 is just one part of that. And it is the part that would ensure that the commercial carriers support the same level of care that Medicaid is doing and intending to do in the state, and that's why it was filed. What we have learned since we filed it was that some of the carriers actually already do cover these services, and that some of the problems are the availability of the services that we are trying to get covered. But guaranteeing, or at least making sure that that coverage is just one of the most fundamental components of being able to provide these children with appropriate care is what this bill attempts to do. And I'm happy to take any questions.
Thank you, Senator. Any questions from the committee? Senator Bradley.
Yeah, thank you, Mr. Chairman. Senator Sherman, obviously you, Senator Whitley, and myself have been meeting with carriers. We've been meeting with advocates and others for the last 2 or 3 months on this issue. Would you agree with me if we're able to find a non-legislative solution that would probably be a quicker, better result for the people that we all want to help, if, and it's a big if, that's possible?
Absolutely, Senator Bradley. Thank you for the question. I am a big believer that we should really try to get these problems solved outside of the statute, and yet if that can't be done, or if there's a modification that would facilitate being able to provide the appropriate care for these children that would not require statutory change or legislation, I'd be all for it.
Thank you.
Any other questions? Thank you, Senator.
Thanks, everybody.
Cameron.
Okay, next is Senator Whitley. Senator Whitley, you should be able to unmute yourself.
Good afternoon. Can you hear me okay?
Yes, we can, Senator. Go right ahead.
Thank you, Mr. Chair, and good afternoon, members of the committee. For the record, I'm Becky Whitley, the senator from District 15, and I'm proud to represent the communities of Concord, Henniker, Hopkinton, and Warner. So I'm here to testify in favor of SB 70 for lots of reasons. The first is that there is a great coalition of folks working together, multidisciplinary stakeholders, all working together to try to fix this problem. I don't have to tell you that we are moving through unprecedented times. We're seeing a rising number of children and adults in crisis who desperately need support. And I think we should be doing everything possible to avoid the need for anyone in a mental health crisis to seek treatment in our emergency rooms. Now, I worked really hard with my former colleague, Senator Feltus, on implementation of Senate Bill 14 with many folks on this committee and many stakeholders. And while Senate Bill 14 is not stood up, as it should be at this point, we are working very hard to make sure that all the money appropriated for that bill is spent, and it is available to build up the system so that no child has to wait. But the reality is that the children that are waiting in ERs are not just children on Medicaid. So as Senator Sherman said, we need a multi-pronged solution here. We need to couple the reforms in SB 14 with a whole host of reforms to build this system. Last week, 35 children waited in an ER for treatment. The record during the pandemic was even higher. This is evidence of a broken system that requires everyone at the table to work towards a solution. Now, I agree this bill is only part of the solution to start getting this number down, because children should never have to end up waiting in an ER for care, not even one. We need to prevent crises like these and expand access to the care described in this bill that will prevent children going to crisis, prevent children having to seek care in the ER, and then if they do end up in the ER, to get them out as fast as possible. So thank you so much for considering this bill, and I'm happy to take any questions.
Thank you, Senator. Any questions from the committee? Seeing none, thank you very much.
Thank you.
Cameron?
Okay, so the next two individuals on my list are Moira O'Neill from the Office of the Child Advocate and Jenny O'Higgins from DHHS. However, both of them have sent me emails saying they couldn't stay on the call. So the next person on the list is Tyler Brannon from the Insurance Department. Tyler, you should be able to unmute yourself.
I can, yes. Hopefully you can hear me now. So Tyler Brannon with the New Hampshire Insurance Department, and we do not have a position on the bill. We do find some questions with the original finding section of the bill. There seems to be the conclusion that commercially insured patients are not covered for rapid assessment or intervention services. The Insurance Department has participated in a number of the discussions that include both the providers and the carriers, as well as hosting our own as a part of the Commissioner's Mental Health and Addiction Services Advisory Committee. And some of the concerns that were raised and addressed in those conversations didn't identify any actual gaps in coverage by the insurance carrier. So I think that conclusion in the findings section is not consistent with our experience in those discussions. That Mental Health and Addiction Services Advisory Committee is an ongoing group that has been meeting now for a couple of years. And it's a great format to bring together both providers and carriers, as well as members of the public and other stakeholders to talk about issues that come up. So that's kind of a good example of how you can work through some, at least perceived issues, without going through the legislative route. When I look through the bill, it does change a section of the statute that deals with coverage for emergency services. Although we do end up with legislation that is specifically targeting a particular disease or a particular condition somebody has, health insurance generally covers a scope of services. The fact we have a required area for emergency services coverage, that applies regardless of the type of healthcare needs that a particular patient may have. By including this specific section addressing kind of mental health and dealing with a particular age group, that's a little inconsistent with the way insurance works. I'd be concerned that potentially people may interpret adding that to the emergency section may mean something different, or may mean that there's limitations on coverage that wouldn't have otherwise existed. There is reference in the legislation to coverage for expenses arising from the use of emergency services. Potentially that means something beyond traditional medical care for some groups of people. That's not how the insurance department would interpret it. So hopefully there is kind of a consistent interpretation of the legislation in the way that it really is ensuring coverage for what people already have. We do have a general concern about specifying coverage for a particular disease in legislation. Even this particular bill makes reference to behavioral health and mental health, and that's a good example of what actually each means over time. We have the Mental Health Parity Act. Behavioral health started to be used more commonly. Some people suggested it means something potentially a little bit different. So I think to the extent that legislation is considered sometimes being too specific or adding something that doesn't really provide a lot of value can create issues down the road. So just some general concerns, but I'm happy to take any questions you may have.
Thank you, Tyler. Any questions from the committee? Seeing none, thank you very much.
Thank you.
Okay, the next person on my list is Jake Berry. Jake, you should be able to unmute yourself.
Perfect. Thank you very much, Cameron. Mr. Chairman, honorable members of the committee, my name is Jake Berry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization that works to address behavioral health issues across our state, especially those facing children. I don't want to repeat too much of what you've heard here this afternoon, but I do want to emphasize New Future's strong support for this bill. As you know, our state's facing not just the COVID-19 pandemic, but also a behavioral health crisis that's severely impacting the health of our children in our state. Across New Hampshire, 1 out of every 5 children has a diagnosable mental health disorder. Of those this past week, as many as 34 were sitting in emergency rooms awaiting critical behavioral health services. This represents a failure not just for these children and families, but for our whole behavioral health system, and it's one we must work to correct. Certainly, the challenges facing our behavioral health system are myriad and they're complex, but this bill we're here to discuss today would take an important step increasing access to mental health treatment for children and families in need. By requiring commercial insurance carriers to cover emergency behavioral health services, SB 70 would go far to ensure access to treatment exactly when children need it most. Though some carriers already cover some of these services, this bill would ensure they're available to all families regardless of their insurance coverage. This would not only help to ensure immediate support for those children awaiting services at any given time, but it will help the treatment providers build out their services to meet children and families' needs into the future. And with the trauma certain to be left by COVID-19, these services will certainly continue to be needed in the months and years to come. The passage of SB 70 would represent a critical support, not just for the children and families of our state today, but a critical investment in the overall health and wellness of our state for generations to come. So we ask you vote this bill ought to pass, and I'm happy to take questions.
Thank you very much, Mr. Berry. Any questions from the committee? Seeing none, thank you for your testimony.
Thank you.
Cameron?
Okay, the next person is former Senator Bragdon. Senator Bragdon, you should be able to unmute yourself.
Yes, thank you, Karen. Thank you, Mr. Chairman, members of the committee. For the record, Peter Bragdon, representing Harvard Pilgrim Healthcare, the state's only not-for-profit health insurer, an insurance company that was founded by doctors, providing coverage for over 100,000 of our friends and neighbors here in the Granite State, and today testifying in opposition to Senate Bill 70. First, let me be clear, though, that Harvard Pilgrim is committed to ensuring all our members receive the right care at the right time and in the right setting. Emergency room boarding in the midst of a mental health crisis can be a very scary experience and one we do not wish anyone to endure. While we have not seen an increase in our members boarding throughout the last year, even having one boarder is one too many. We oppose Senate Bill 70 because it essentially creates two types of mandates. One, a mandate for services that we already cover. So in this case, a mandate is not needed. And secondly, a mandate for services that are not well defined and for which there are not adequate resources. As Senator Whitley pointed out, we have not stood up the services that were required by the prior mental health bill that passed, and those aren't currently available. So in this case, it's a mandate which cannot be met. When we learn that a Harvard Pilgrim member is boarding in the emergency room, we reach out to the facility to see if we can help locating appropriate placement, including facilities in neighboring states if that's appropriate. We are also in daily contact with the boarding facility to make sure to see if the member's clinical presentation has changed, which may open up other treatment options. Harvard Pilgrim offers a range of treatment options, including crisis assessments, crisis intervention, and crisis stabilization services. These are listed in Senate Bill 70 as items A, B, and C. We also offer outpatient treatment and residential treatment. We also offer care management in these cases. Our care management program can support families in coordination of care, education on available treatments or services, and identifying available resources. These are all services we provide when one of our members is in an emergency room boarding situation. A mandate to cover these services is not needed, as these are covered services. The problem we continue to encounter, however, is a lack of beds and service providers in the residential and at-home area. Mandating that we cover services which are not properly resourced will not solve the problem. And in a related matter, paragraph D uses the term, quote, intensive at-home services, which is vague and subject to various interpretations. And finally, we're concerned about Roman paragraphs 2 and 3, which limit our use of prior authorization. Quite often, emergency room boarders are known to us. So the prior authorization process allows us to, one, share historical information and insights. For instance, our clinical team may be familiar with a particular patient who shows up at an emergency room, and they may not be familiar with that person, and can provide helpful insights. Prior authorization also improves coordination of care, and prior authorization also activates our care management teams who can assist with member engagement in continuing care as soon as possible. Not activating these services can result in frequent readmissions to higher levels of care and a lack of post-discharge follow-up. Prior authorization is not a mother may I request, as some would try to portray it. In addition to verification of coverage for service, thus avoiding a situation where a member has to pay for an uncovered service, Prior authorization is the fundamental step to integrate the patient into a host of services and support that can be vital to successful treatment. Harvard Pilgrim is committed to being part of the solution to this problem. We look forward to continuing to work with all relevant stakeholders to come up with a solution that makes sense. However, for the reasons I detailed above, mandating services that are already being covered and mandating services for which resources and providers do not exist, we recommend the committee find the bill inexpedient to legislate. Thank you very much.
Thank you, Senator. Any questions? Thank you very much.
Okay, next is Sabrina Dunlap. Sabrina, you should be able to unmute yourself.
Hi, thank you. Thank you, Mr. Chairman and members of the committee. I'm Sabrina Dunlap, Director of Government Relations at Anthem. I echo a lot of what Peter Bragdon just said, so I'll try to keep it brief. Anthem does oppose SB 70, but it's not because we disagree with the goal of improving access to mental health services. We certainly agree with that. It's because the bill does not further that goal. And we do think this is a case where a non-legislative solution makes the most sense. And we agree with the services outlined in SB 70, but it's really important to note we already do cover all of the services listed. We've long provided reimbursement for mental health evaluations in the ER, and emergency services do not require prior authorization. We also cover intensive in-home services and residential treatment. But the problem is, as it's been noted, it's really difficult and sometimes impossible to find these services in New Hampshire. And I also want to note, I know it's been mentioned, but in conjunction with SB 70, stakeholders, including carriers, advocates, providers, policymakers, have been engaged in very productive discussions on addressing the persistent gaps and weaknesses in the state's mental health delivery system. And there are many complex issues and problems that need to be solved, but it's become very clear that coverage is not the problem. It truly is the lack of providers and services available in the intermediate level of care, like home services, as well as a severe lack of residential beds for more complex issues. We've spent quite a bit of time discussing how to stand up these services that we all agree are essential. And I think it's this discussion with stakeholders that we need to continue to make progress and make a difference for patients. We are ready and eager to cover needed services, but in many cases, they simply are not available. This bill does not help with that underlying problem. And in some ways, I think it serves as a bit of a distraction from the relevant underlying problems because it only focuses on coverage. And again, coverage is not the barrier to care here. So we need to be focused on how to increase availability to the many mental health services that are needed. And this legislation just does not do that. And in closing, I've just emphasized again, we are aligned with the bill sponsors and other stakeholders here. We really, really want to solve these youth mental health issues. And we want to provide kids with the appropriate level of mental health care. But we just don't think that this bill gets us towards that goal. So thank you very much. And I'm happy to take any questions.
Oh, thank you. Senator Bradley mentioned the non-legislative action between all parties is a possibility. Do you see that as being possible?
Thank you for that question. I do. I really do. I think the conversations, we've had several really good, pretty lengthy calls with a wide range of stakeholders. I think we could probably bring in some more hospitals because, you know, services you get at the emergency department really varies depending on the hospital. So I think they need to be part of the conversation. But I really think that these conversations where we're drilling down on where the gaps are and, you know, like Peter said, you can mandate something, but if the services aren't there, there's really not much we can do. So I don't think this bill really moves the needle. And I do think it's the non-legislative option, the discussions we're having, that really is the solution here.
Great, thank you. Any other questions from the committee? Senator Susie.
Thank you, Mr. Chairman. And thank you, Ms. Dunlap, for your testimony. Just wondered, the state obviously mandates services, but is it just the state's obligation to build up network capacity, or do the providers and the insurers have some obligation to assist in doing that?
Thank you, Senator Susie. Yeah, I do think, I mean, we are at the table and we absolutely have a responsibility to help, and we are ready to help. We want to be part of the solution. We like to look for creative ways to get services to people. So I absolutely think that providers and carriers are at the table and looking for solutions together.
Thank you.
Any other questions? Thank you, Ms. Dunlap.
Okay, the next person on my list is Chris Kennedy. However, I do not see him. So the last person on my list is Evan Rossett. Evan, you should be able to unmute yourself.
Thank you very much. My name is Evan Rosette. I'm here with my 13-year-old daughter, Morgan, and we really appreciate the opportunity to testify in support of Senate Bill 70. Back in October 2020, my daughter came to me on a Sunday evening and said, I don't feel safe. What can we do? And I called Seacoast Mental Health, and we ended up in the emergency department for a week while we waited for placement at Hampstead Hospital. Ultimately, Hampstead Hospital was great. The coping skills and things she learned helped tremendously, and she's doing very well now. But I will tell you that that week that she was in Exeter Hospital in what looks to me like something you would see in a TV or a movie in a prison cell was very tough. She didn't have any services. There were no interventions. She couldn't do her schoolwork. She basically just sat there and waited for a week for placement, and it was very hard to handle. I'd like her to offer her perspective as well. Morgan?
Thank you. I just, like he said I didn't feel safe, so we went. And yes, people did come and check on me every day, but it was mostly, are you feeling suicidal? And I would say yes. And then they would leave and say, I'll see you tomorrow. And I don't think that's the right amount of care someone should get if they really do need it. And it was to the point where I wondered if I could fake being fine so I could go home. I could have had more progress if I did therapy when I was at home instead of being in the emergency room. If a kid is brave enough to ask for help, they should get as much as they can.
Thank you very much. I appreciate everyone's work on this, everyone around the state who advocates for mental health, especially for our children.
I'm glad you stood strong there. Any questions from the committee? Senator Susie.
Yes, for Mr. Rossett. Did you have assistance from your insurer? Did you feel that they were advocating to help you find that placement, or?
No, I will admit, we have Harvard Pilgrim, and we were at Exeter Hospital. I don't mind sharing that. And I had reached out to Harvard Pilgrim because I was concerned that they were going to be essentially helping to pay for a weekend, or at the time, I didn't know how long it was going to be, every day in the emergency room, and how expensive that was waiting for placement. We were trying to find anything we could in the Northeast. I didn't get the impression that that was happening. I felt like the folks in the hospital kept telling us that they were doing everything they could, but I didn't get that impression when I spoke to them with my concerns about how long it was taking.
Thank you so much. And thank you, Morgan, for your testimony as well.
Anyone else? Thank you very much for your testimony today. Cameron?
Okay, I have two folks raising their hand to speak for the first time, then Senator Sherman has his hand raised to speak for a second time.
Okay, bring Senator in, please.
Senator Sherman, you should be able to unmute yourself.
Thank you so much. I'll be super brief. In my 35 years of medical practice, prior authorization has not been as rosy as was painted by former Senator Bragdon. In fact, it has been such an impediment to care that many of us who were there in 2016 when Senator Bradley and I and others put in some of the bills on substance use, that we actually waived prior authorization for the 48 hours before transfer, because it did represent more than a speed bump. It represented a halt to care. So the concept of waiving prior authorization for 72 hours is not to not allow it happen, but rather to make sure that there is no impediment to a patient getting the care they need when they need it, which I think is what Sabrina Dunlap said is their goal as well. I think we're all on the same page, and I think Mr. Brannon and everyone else has said this is not the solution, and I never claimed it was. This is a part of the solution. This is one component to a very complex puzzle, but it is a component that we need to reinforce, as we just heard from Mr. Rosette. So thank you very much for your time.
Senator. Cameron?
Okay, the next individual is identified only by a phone number ending in 66. Can you identify yourself for the record, please, and unmute? There you go.
I'm sorry, Mr. Chairman, can you hear me?
Yes, I can.
Hi, thanks for taking the time. This is Chris Kennedy. I apologize, I had to drop the Zoom, but I still am listening by phone. For the record, Mr. Chairman, Chris Kennedy, Vice President of External Relations for New Hampshire Healthy Families. For those of you who are not familiar with us, New Hampshire Healthy Families is both a managed care, Medicaid managed care organization here in the state, as well as a commercial insurance carrier under the moniker of Ambetter, selling plans on exchange exclusively in the individual market. I want to offer testimony, and I will do my best to be brief. I know it's been a long day and void of redundancy. I'm here as well to offer what I guess I would characterize as a reluctant opposition to the bill. And again, echoing the sentiment of many of my colleagues in the industry, not because we certainly don't acknowledge that the issue is an extremely serious one, nor do we disavow, frankly, the role that the insurance industry has in solving the problem, as Senator Susi alluded to. In addition to that, I just want to say I want to thank Senators Sherman and Whitley and Bradley and others for convening what I think has really been a very useful and very constructive dialogue of stakeholders over the last several weeks and months. I, again, with many of my colleagues in the industry, can sit here today and commit with great certainty that I feel comfortable that we could achieve the kind of non-legislative solution that's been discussed here. Before I go into just the specific issues with the bill, Mr. Chairman, I'd also be remiss if I just didn't take a moment to acknowledge and thank Morgan for her testimony. I will just say it takes a tremendous act of courage to tell the story that she just told, especially at her age. And we need to solve this problem for Morgan and so many other kids like her, who unfortunately have been confronted with these set of circumstances in EDs across the state. Two really parts to my concern and opposition to Senate Bill 70, Mr. Chairman. One, again, you've heard a little bit before, it tackles the issue with the wrong approach. ED boarding in the state is not a manifestation of a lack of insurance coverage for the services identified and enumerated in the bill. It's really predominantly an issue arising out of insufficient service capacity and in certain cases, insufficient inpatient infrastructure, along with a lack of a robust network of providers there to fulfill and support the services we're talking about. Also, as has been discussed, many insurance carriers in the market are covering most, if not all, of the services identified in the bill. Speaking for New Hampshire Healthy Families, Ambetter, we're covering certainly the mental health crisis assessment, certainly crisis intervention and stabilization services, as well as residential treatment. The issue we have consistently in working to mitigate ED boarding across the state is finding a robust network of providers to deliver the services to our members. And I would just also acknowledge again another point that Senator Susi raised, but we certainly see it, Senator, as part of our responsibility to develop, build, and support provider networks. We've been doing so and working on this issue for a number of years in concert with the Department of Health and Human Services on the Medicaid side. We're currently engaged with the department and a number of other provider stakeholders on a pilot program that would seek to do just that, to build and support a network of providers to address and be able to fulfill some of the intensive in-home support services that are identified in the bill. But I will just say, in addition to the capacity challenges, I do have a few technical concerns with the bill, and I realize there's been a lot of discussion of a non-legislative solution. I very much hope that prospect exists. Like I said, I think there's a a great degree of confidence across the industry that one could certainly be achieved in short order that supports the endeavor that we're all trying to support here. But there are just two issues that I did just want to raise in addition to the approach, Mr. Chairman. And one is in Section 2, Roman 1, line 24 of the bill. And it is a line that refers to, in addition to the expansion of emergency services, the definition of emergency services as contemplated in the bill, it requires carriers to provide coverage for expenses, quote, arising from the use of those emergency services. So on the one hand, the bill mandates insurance carriers cover a set of services that extend beyond conventional emergency services. On the other hand, it allows for the coverage of expenses of all services and care arising from the use of those emergency services. I would contend to you, Mr. Chairman, that that's overly broad and probably gets beyond the scope of what the legislation is actually trying to accomplish. The only other issue specifically that I'll draw attention to is on page 2, line 1, in a set of the services that are mandated in the bill. The notion of intensive in-home services, and former Senator Bragdon, I think, spoke a little to this. This is really a more amorphous array of services that I think requires additional definition and really additional examination as to whether or not these services are really supported in the community. I think, as was mentioned again by a number of carriers, a great deal of the other services contemplated in the bill are currently covered. And I think one of the greatest challenges, as I think exemplified in Morgan's case, is how, as insurance carriers, how as providers are we working together to convey to our collective members and patients that these services are available to them and covered under insurance. And so I think that could be really one of the really positive byproducts of this public policy dialogue, is providers and insurers working together alike to make sure we're doing a better job at educating our members as to the services that are available to them. So with that, Mr. Chairman, I thank you for the time. I'd certainly be happy to take any questions and answer them to the best of my ability, but I'll conclude my testimony there.
Thank you. Any questions from the committee? Seeing none, thank you very much for your testimony. Karen?
Okay, next we have Ken Norton. Ken, you should be able to unmute yourself.
Thank you, Mr. Chairman, members of the committee. My name is Ken Norton. I'm the Executive Director of NAMI New Hampshire, the National Alliance on Mental Illness. We are not treatment providers per se. Our mission is to improve the lives of all people impacted by mental illness through support, education, and advocacy. I'm also have family members with mental illness and have been through the system, have also been a licensed foster parent. And I speak today with a certain amount of frustration. In January of 2013, NAMI New Hampshire held a press conference in the Legislative Office Building about what was then the emerging crisis of emergency department boarding. And we had 15 partners with us at that press conference. At that time, the average number of children being boarded was between 1 and 2. When we entered this year, the second quarter of 2020, we had 7 children on average being boarded. And at the press conference, I had said that emergency department boarding is wrong medically, legally, ethically, morally, and economically. And as we move through 2020, as a result of the pandemic or wherever the situation where we're at, we went from into the third quarter, 10 children on average being boarded, and into the fourth quarter, 16 children per day on average being boarded. And as you heard earlier, we also in that fourth quarter hit at 1.36 children on one day. Those kids are ending up, and thank you, Morgan, and your family for providing testimony, sometimes weeks, sitting in emergency rooms. And I think that, you know, part of the equation here that I think is really important to consider is that emergency department boarding is as you've heard testimony from other people, is just part of the equation of what we're looking at. But I think an important part of the equation is to recognize that most of those young people in emergency rooms have been determined to be have a likelihood of danger to themselves or others. And I think another important statistic is that suicide is the second leading cause of death in our state for young people ages 10 through 34. And I think that I think Senator Susi's question was very much on point, because I have been in countless meetings, countless legislative hearings. I'm on the New Hampshire Insurance Department Advisory Board that Tyler Brennan mentioned. And I think part of what underlies all of this is an assumption that people with serious mental illness are the state's problem. And so by example, I would ask, how is it that we only have one facility in the state for children to have inpatient admission to? How are the insurance carriers ensuring that there's an adequate network and supply of services for the people that they are insuring, when there's only one facility that's primarily now the state facility in Hampstead Hospital? And so while I think Senator Bradley has said that this is not the solution, it's part of the solution, I think that that's really important part of where we are now. And we need to do something. At what point are we, if it's not 30 kids, is it 40 kids? Is it 50 kids? At what point are we going to begin to solve this problem? And yes, we have all worked together. We have all worked collaboratively, but we are faced with this crisis in exponential numbers from what we've seen previously. And with that, I would ask you to support this bill, and I'm happy to answer any questions.
Thank you, Mr. Norton. Any questions from the committee members? Seeing none, thank you very much.
Okay, the very last hand I have is from Representative Perez. Representative, you should be able to unmute yourself.
Thank you. Thank you again for letting me speak. I'm here to support Bill 70, SB 70. During the pandemic, I personally see 3 young lives lost in my community from mental health. So I believe this is something that we need to work on. And to be honest, it's so sad for me to see 3 lives gone. 3 families missing someone in the dinner table. So I would ask you to support SB 70. Thank you.
Thank you, Representative. Oh, if that's it for.
Jenny O'Higgins from HHS has raised her hand.
Go ahead.
All right, Jenny, you should be able to unmute yourself.
Hi there. I'm sorry I was late to the session. I had an unavoidable conflict that I had to step out for a minute, and I'm glad to just have been able to come back on. I'm a legislative liaison and senior policy analyst for the Division of Behavioral Health at DHHS. So thank you to both the chair and the members of the committee for just hearing from me. I just wanted to make sure to state that SB 70 aligns with what DHHS has been doing on the Medicaid side, opening up access to codes and to providers to address the ED boarding issues for children with commercial insurance. So New Hampshire is seeing an increase for the first time in privately insured kids boarding in the EDs, and SB 70 compels the private insurance to cover the crisis and other services necessary to get kids out of the EDs and keep them out. So this approach on the Medicaid side has been able to ensure that kids have access to services that could get them home safely while waiting for psychiatric beds or keep them home safely. So it really has been another tool in our toolbox. And I know that Erica Ungarelli, who was not able to represent DHHS today, has worked on this bill with those legislators. So I just wanted to make sure that we were here today. And then if you had any questions for DHHS, that I could bring those back as well.
Thank you very much. Any questions from the committee members? Seeing none, thank you for the work you've been doing to bring this forward.
Senator, there are no hands raised at this time.
Very good. Then I'll close the hearing on Senate Bill 70 and entertain a motion to recess. No one wants to recess.
I do.
So, Mr. Chairman, you're not ready to go into executive session?
Senator, I was looking at the list. I don't see anything, maybe you do, that we could exec today.
Did the amendment on Senate Bill 38 get circulated?
I did send an email out, I believe, to all the aides.
Yes, wait, I am so sorry. I thought we 38.
Medical marijuana,
Yeah,
cannabis.
I'm just trying to find it on my list here. So how would you like, so Senate Bill 38, we voted on that once before. How would we go about?
So it was recommitted to the committee. So my understanding is the committee now has possession of the bill and can take it up as we would in the normal process.
And if you would give me a motion to go into
All right.
executive session.
We go into executive session.
Second.
We have a motion for executive session by Bradley, second by Susie. We'll take a roll. Senator Bradley,
Yes.
Senator Susie,
Yes.
Senator Kavanaugh,
Yes.
and Senator Gannon,
Yes.
and Senator French thinks it's a great idea. Yes. We'll take up Senate Bill 38.
Senator, I believe you would have to reconsider our previous vote and then open it up for a new vote.
At the procedure.
Yeah, I'm not sure, but you know what? We might as well do it because then there can't be a problem.
Okay.
That would be my recommendation as well.
Thank you.
Well, thank you. Thank you. Thank you.
We're here to help you, Mr.
I
Chairman.
appreciate that.
We're all in this together.
So someone on the prevailing side,
I'll move that we reconsider the action that we took when we had this bill in executive session prior to.
I will second.
motion to reconsider on SB 38 by Senator Bradley, seconded by Susie. We'll take a roll call. Senator Susie,
Yes.
Senator Bradley,
Yes.
Senator Kavanaugh,
Yes.
Senator Gannon,
Yes.
Senator French says yes. Do I have another motion?
I would move the amendment, and I apologize, maybe Aaron can put it up on the screen as I don't have the number, but I'd move it ought to pass.
I'll put it up on my screen. It's Amendment 0258S.
Would you like to discuss that, Senator?
Yeah, what that amendment does, and this was per your suggestion, Mr. Chairman, is that we make it clear that we're not creating in the future potential monopolies if there's ever recreational marijuana allowed in New Hampshire. By clarifying Senate Bill 38 through the statement of intent, that it only applies to those, as you see in line 13, alternative treatment centers that held a license as of January 2021. I believe that satisfies the concern that you raised.
It does. Thank you. Any other discussion?
So if I could, Mr. Chairman, so the ought to pass is on the underlying bill. I would second that. And then we would need a motion on the amendment as well, correct?
That's just what I was going to say.
I think that with the reconsideration, I think we revert back to the underlying motion of ought to pass, which was made by Senator Bradley and Senator Kavanaugh on the 19th of January, but I'm not quite sure.
Well,
That's how I would interpret it as well, that we're already on the underlying motion.
So we have a motion of ought to pass on this amendment. Do we have that
Yes,
already?
I moved that. Yeah.
Senator Bradley moved it.
Second that as well.
It was Moved by Senator Bradley, seconded by Senator Susie. We'll take a roll. Senator Bradley,
Yes.
Senator Susie,
Yes.
Senator Kavanaugh,
Yes.
Senator Gannon,
Yes.
Senator French says yes. Now take a motion on ought to pass as amended.
I would again move ought to pass as amended.
Second.
By Bradley, seconded by Susie. Senator Susie,
Yes.
Senator Bradley,
Yes.
Senator Gannon,
Yes.
Senator Kavanaugh,
Yes.
Senator French says yes.
Oh my God, I'm gonna move consent.
I don't blame you one bit. Now's the time to do it. We have a motion for consent by Senator Bradley and
Second.
seconded by Senator Kavanaugh. Senator Bradley,
Yes.
Senator Susie,
Yes.
Senator Kavanaugh,
Yes.
Senator Gannon,
Yeah.
and Senator French says yes.
So just a question of Senator Susie. We had gone a little bit back and forth on Senator Hennessy's bill, Senate Bill 68. Do you want to take that up today, or did you still want to talk to the Executive Director of the Human Rights Commission?
I literally just got off the phone a few moments ago with the Executive Director of the Human Rights Commission, and I think I'm comfortable with the language at this point.
Before you move on to that, someone needs to take out Senate Bill 38.
That'd be Senator Bradley.
Then if Senator Susie's good to go, I'm going to move ought to pass on Senate Bill 68.
Senate Bill 68.
And as you recall, that was Senator Hennessy's bill on, hang on a minute.
Yes.
It dealt with pregnancy protections for obviously anybody that was pregnant on the job.
Would you speak to that, Senator?
Well, I think that this was a piece of legislation that the governor asked me to submit last year. I did. It got caught up in, the end of the session, and it never made it across the finish line. So we have a second chance. As I recall, there was absolutely no opposition to the bill when we had the hearing on 126. And so I think, this is common sense and we should go forward with it.
So we have a motion ought to pass on Senate Bill 68. And Susie, did you second that?
No, I was just going to speak to the bill.
Okay,
Somebody else wants to second.
I'll
that.
second it.
Okay. I think the concern that was raised at the hearing, and that was what I wanted to follow up on, was regarding the interpretation of or a concern that was raised about complications associated with the pregnancy and whether that related condition was interpreted to be a disability, and whether or not that was actionable in New Hampshire law. I think there was a bit of misunderstanding, and after speaking to the Executive Director of the Human Rights Commission, she assures me that the language as presented would, in cases of the pregnancy itself, in cases of conditions arising as a result of the pregnancy, it would cover. I think the only I'm not going to hold it up for this, but I think the only thing we might consider in the future is defining what a reasonable accommodation is. But I think it should move forward the way it is.
Mr. Chairman, can I ask Senator Susie a question?
She'll accept.
I would have a suggestion more. If you and I have a colloquy on the floor, we may be able to establish legislative history on that. Would that be helpful?
Sure, but if everybody's in agreement, we may want to put it on consent. So in which case we wouldn't have that opportunity.
Well, if you take the bill out, you could write it in the blurb.
If I assigned it to her, which I might.
Why don't I just vote against moving it to consent?
Yeah, there you go.
I'll let you, Senator Bradley. How's that?
All right.
So, take a roll call if everyone's ready. Senator Bradley,
Yes.
Senator Susie,
Yes.
Senator Kavanaugh,
Yes.
Senator Gannon,
Yes.
Senator French says yes. Senator Susie, would you like to take that out?
I think Senator Bradley should.
Senator Bradley,
I'll ask him
okay,
a
thank
question.
you.
Okay, thank you.
Okay. Any motion to come out of exec?
I'll move that we come out of executive session.
Second.
Motion to come out of exec by Bradley, seconded by Susie. Senator Bradley,
Yes.
Senator Susie,
Yes.
Senator Gannon,
Yes.
Senator Kavanaugh,
Yes.
Senator French says yes. Motion to recess?
Motion to recess moved.
I think you
Seconded.
need a motion to adjourn. Are you just moving to
Oh,
take a break?
no,
and then come
motion
back?
to adjourn. I'm sorry.
Adjourn,
Thanks, Ken.
adjourn, excuse me. Seconded by Senator Susie, Senator Bradley,
Yes.
Senator Susie,
Yes.
Senator Kavanaugh,
Yes.
Senator Gannon.
Yes.
Senator French says yes, and he says, thank you very much for sticking with us today and getting through this.
Before 5. Good job, Harold.
Ooh, it was tight.
It was tight. Take care.